Welcome, welcome, welcome everyone to our Equity in the Law Symposium. We are excited to have you here today. We're going to be getting started shortly, but first we want to let you know a little bit about what you are in for today. I'm Rhonda Baisley Moore, Chief Inclusion and Diversity Officer here at LexisNexis, and I'm joined by our fabulous LexisNexis African Ancestry Network and LexisNexis Rule of Law Foundation Program Director. Adonica, say hello to everyone.
Good morning, everyone. I'm Adonica Black. Thank you so much for joining us here today. We are so excited to share with you the work that our fellows have done this year to advance equity in the law, and we will be getting started just shortly.
I think the first thing that I would want our viewers to know is that advancing the rule of law is absolutely core to who we are here at LexisNexis. It's been a major part of our organization's culture for many years. And like many organizations several years ago, in the face of everything that was happening around racial injustice, we started thinking about what can we do as an organization to eliminate systemic racism in the legal system. Let us stop and show you a quick video to give you a view of all that we're doing to advancing the rule of law around the world.
And as you can see, there has been a massive demonstration.
just love that video. I'm always so inspired by the work that our organization does to advance the rule of law around the world. That's something that many of our talented employees across the globe share as really meaningful and a part of why they love working with LexisNexis.
Absolutely, I couldn't agree more. Even in this fellowship, last year we had over 100 people from across our global organization who came together to support our group of fellows. Adonica, tell us a little bit about our fellowship.
Absolutely. So our fellowship, as Rhonda mentioned, started out of our commitment to advancing the rule of law and eliminating systemic racism in the legal system. So we started a fellowship last year, 2021, in partnership with the Historically Black Colleges and Law School Consortium and the National Bar Association. And in our partnership, we have selected fellows from across this talented pool to advance the rule of law and eliminate systemic racism in our legal system by joining with our LexisNexis team and utilizing our LexisNexis technology to make a more just world. But I don't want you to just take my word for it. I want to hear it from directly our fellows from 2021. So let's listen in here.
I grew up in a small town, and I saw where if you were from a certain side of the track, you didn't get treated as nice as people from the other side of the track. This is our criminal justice system. It's supposed to be here to serve all of us equally, and it doesn't. And so whatever little bit that I can do to make it as equal as possible, that's what I want to do.
We are righting wrongs and correcting transgressions of a system that has existed for the entirety of our nation's history.
Lexis African Ancestry Network and our Rule of Law Foundation teamed up, and they put together this fellowship from the 6 HBCU law schools.
The fellowship is a program that consists of 12 law school students from the 6 HBCU law schools in the United States, and fellows were selected from a large competitive applicant pool for this prestigious fellowship, where they've been awarded $10,000 and the opportunity to work on projects that they've proposed to eliminate systemic racism in the legal system.
One of the things that we wanted to do with the LexisNexis partnership is just really open up the opportunity for students to have access to the incredible resources of LexisNexis in terms of doing broader research that really focus on diversity in the profession.
My project deals with the underrepresentation of women of color, particularly Black women, in leadership roles across law firms.
We're doing papers of publishable quality related to our research. It's important and definitely necessary that our work was of publishable quality, because then this research can be used to further the areas that we're all kind of approaching.
I'm surrounded by individuals who you can just see that they're achieving at a high level at their institutions. Their ideas are just mind-blowing in the topics that they are tackling and the problems that they're tackling.
The best part of this fellowship so far has been just meeting such wonderful people, meeting other students from law school that are just as bright and ambitious as I am, meeting the LexisNexis employees who are so helpful and so generous, and they seem to be really invested in my success.
This fellowship celebrates everything that makes LexisNexis special, which is our people who are inspired to advance the rule of law.
I was given the opportunity to present to all of the deans of the law schools involved in the fellowship. I realized we've been able to do so much. I've been able to connect with really awesome people. My mentor for the program is the vice president for Law 360, and that is just incredible. And the way that she has helped me develop my project, the way she's helped me think about it, was all reflected in that presentation.
Working at Law 360 and with LexisNexis, our purpose has always been to support the rule of law throughout the globe. Being part of this fellowship alongside the Rule of Law Foundation has really meant for me that we can sort of move past good intention and really start taking action, and it's felt real, it's felt practical.
The endeavor into the law and graduating and passing the bar, in my opinion, will essentially change my family tree. It will change the trajectory and the boundaries that we may have set for ourselves based on those around us and our family backgrounds.
Our fellows are leaving a legacy. And I believe that the work that they're doing now will be looked upon as really heroic in the years to come. And I'm so privileged that LexisNexis gets to be a part of that journey with them.
Ending systemic racism is going to be something that we need to be committed to for a long, long time. And so having dedicated people taking on these projects in new ways and bringing in new ideas to the fellowship will be something that we'll look forward to with great interest.
I would describe the fellowship as challenging, creative, and hopeful.
Fellowship is inspiring, challenging, and most importantly, exciting.
The fellowship is a uniquely transformative opportunity.
Hardworking, striving for success, eliminating systemic racism.
I would describe the program as life-changing work.
The fellowship is prolific, profound, and powerful.
It's always so wonderful to look back, and how inspiring, right? When we think about the start of this program and the vision of how we might eliminate systemic racism in the legal system. We onboarded those fellows, and a key part of their onboarding was an innovation retreat. I want to show everyone just how special it was. Let's take a look at that video.
The program has been really great. I just feel this energy and excitement from my fellow peers. We're all trying to make change within the legal field.
What I'm hoping to gain from this program is just the experience, being able to help persons of color to receive an equitable and fair shake in the legal field.
LexisNexis is a large organization. We have lots of talent and lots of resources. And if we're not taking those items and building them into something that can help society, can help amplify the voices of these talented fellows, we're not doing it right.
For so many years, Black lawyers were not at the table. So I think that this program allows us to come and be at the table.
This program offers minority students an opportunity not only to invest in a program and in themselves to work on a project, a passion project, but it also is teaching them practical life skills, professional skills.
I'm really enjoying the need for research that we're just really getting into. I like to write, I like to research, and I'm pretty curious, so that's been fun. And it's also fun meeting other fellows from all over and just getting to know people that I probably wouldn't have a chance to connect with otherwise.
Having so many mentors here, so many people who are willing to help and put their hands in and really say, hey, I can do this, or I can connect you to somebody, or I can connect you to somebody who can do that. It's fantastic.
The LexisNexis team has been so intentional about making us feel special, making us feel like we're in a community that cares about us and our projects. Everything from the keynote speakers to the presentations that we have around the room. I feel really supported and excited about my project just because of the support that I have.
I love that video. We had such a great time together in Raleigh. We had such an opportunity to really innovate and think through how we would address systemic racism in our legal system. And now we're back together. We're back together in Washington, D.C., and we are so excited for our Equity in the Law Summit and Symposium to continue.
It is going to be a wonderful day, and we are glad that you are here with us. And let us tell you how you can stay involved with us throughout the day. Definitely use our hashtag LN Fellowship. Hashtag LN Fellowship. Definitely use that. We'd love for you to learn more about the great work that we're doing through our Rule of Law Foundation. We have a fellowship site and symposium site where you can learn more about the great work that is being done, and you can even get involved by joining us, connecting with us, and donating. And we'd love to get involved or get engaged with you in any of those ways. So stay tuned and get ready. Symposium 2022 Equity in the Law is about to begin.
Good morning, everyone. Love that. I'm Adonica Black. We'll see on the next slide coming up here. And I am the Director of Global Talent Development and Inclusion at LexisNexis Legal and Professional. And I also have the honor of being the Director of the Fellowship Program. And I want to start by thanking you all for answering our call. The Fellowship Program is a partnership between the Historically Black Colleges and Law School Consortium, our LexisNexis Legal and Professional Technology and Talent, and the National Bar Association, which is the largest bar association of Black legal practitioners globally. And you have all together answered the call to advance the rule of law and eliminate systemic racism in the legal system. All of you in this room are here because you are a part of this program and you're committed to the work, and we really want to thank you for answering our call. So I want to tell you a bit about how we have structured our presentations today and our fellowship overall. It's a cluster model because when we thought about eliminating systemic racism, that's a daunting task. So we needed to be incremental and really effective. And so we implemented clusters that look at the full way that Black lives encounter the legal system from what we like to say cradle to grave. So we start with youth and looking at how Black youth in America and really over the world are treated inequitably by the legal system, much of it doing with the school to prison pipeline and how do we mitigate those issues. And then we look at how do we increase access, opportunity, exposure, and trust in the legal system from the youth so that we are creating new practitioners in the legal system who aspire to be a part of what we do here. And that brings us to legal education, creating more diverse and equitable education in our legal system. And once you've been educated, you then need to ascend to being leaders. So we're looking at leadership in the legal system and creating more diverse leaders in our profession. As we continue, we look at how our system enacts justice in the court system, reviewing how juries are selected, reviewing how judges review their assignments, and using our technology, our data, our analytics to try to mitigate any bias. We then take a look at the criminal justice system and the disparate impact and judgments that have been made by the legal system, and we support that with data to mitigate those disparate impact. And then finally, we look at racial equity in wealth and ownership in our legal system. That underpins everything that we need to be able to excel further as a country, as a globe, together, all of us. And so our program is really about access and opportunity. We're giving our fellows access and opportunity to advance their own professional and legal development and help to advance the rule of law, but we're also giving you all access and opportunity. You all have a charge here to not just watch, but to participate. Think about what we've done and how you can make us go further. And so finally, I'd love to introduce our keynote speaker, who also answered the call. She might joke and say that I wouldn't take no for an answer when I called her, but I rebut that because you never said no. You immediately were on board, and I really thank you. So I'd like to introduce you all to a lady who needs no introduction. I think when you all heard about our keynote speaker, many people decided to attend. Soledad O'Brien. Soledad is an award-winning documentarian, journalist, speaker, author, philanthropist, entrepreneur, and host of the weekly syndicated political show, Matter of Fact. She's a founder of Soledad O'Brien Productions, a multi-platform media production company dedicated to telling empowering and authentic stories on a range of social issues. And she is a thought leader who has had national impact through her speeches, numerous documentaries, and her presence on the op-ed pages of platforms like the New York Times. And through her foundation with her husband, she's the founder of the Powerful Foundation that helps young women get to and through college. Soledad is a champion of diversity. She gives voices to the underserved and the disenfranchised. Many of you may have seen her Emmy-winning reporting on acclaimed documentary series Black in America and Latino in America. And she always answers the call. So I'd like to welcome Soledad O'Brien. Thank you.
By all means. That could have gone a lot of different ways, so I'm glad I didn't topple off the stage. That would not be a strong start. I'm going to take these notes, and I know the fear when someone takes your notes off the podium, so I'm going to keep them in order, and I'm going to move them right here for now. And Adonica, thank you for inviting me. I think this is so important and so essential that you're right. I didn't say no, but I knew I couldn't say no because she's not the kind of person you say no to. So I am truly honored to be here. I'm going to talk a little bit about the rule of law, which is a little ironic since I'm a reporter and not a lawyer. But I think everyone in this room knows just how important and essential it is. And I'd like to direct my comments mostly to the young people who are presenting today. Everybody breathe. You guys have got to breathe. You're freaking me out a little bit up here. Come on. Okay, it's going to be okay. Your presentations are going to be amazing. I'm very much looking forward to them. The law has always disproportionately affected people of color. From voting rights to civil liberties, we have been given centuries of examples that the system is not always equitable. The more the law, in fact, does not serve you, often the more you disengage from the process. And it seems like a bit of a simple equation. The cynicism, the distrust, the sense of nihilism is all built in to widen the distance between those who create and uphold the law and those who are often inadvertently affected by those laws. I'm a champion of diversity, and I wholeheartedly believe in representation in all areas, but I'm also a realist, and I realize that all of the races for representation are not weighted the same. If a prestigious golf course has historically denied membership to Black people, to women, it's a shame, and it should be addressed, but their prejudice practices don't have the same larger overarching consequences on minorities nationwide. I'm an avid equestrian and would love for more people of color to experience the love and the passion that I have for that sport, but if it never becomes more inclusive, the state of our union will still be intact. But that's not the case for the law. A distrust of the law is not an inoculation against it. You cannot opt out of those laws that affect your life and your liberty. The race for representation is, in fact, dire. The lives and livelihoods of the people from the towns and cities that you guys come from, we all come from, will be suppressed and gerrymandered and underserved and under-resourced and over-sentenced by the actions or the inactions that you take in the near and far future. So all of you have a JD in your sights. You will be lawyers before you know it. I know that's scary. Again, take a moment, breathe, it's all gonna be okay. And even for the JD candidate in the group, this time is gonna fly by. And everyone's gonna have an opinion on where your journey should lead. Your parents are going to have thoughts. In many cases, they paid for your education, so they're going to have some big thoughts. Your significant others will like to weigh in. Even your student loans will have an impact on the choices that you make. So as you make these daunting decisions, remember that the scales of justice represent balance. The students who go on to work as public defenders have the same obligations as those who end up on K Street or those who go to academia. You all have a responsibility to maintain the health and wellness of our laws, to see that the catacombs are lit and the cobwebs are dusted away. Black lives and freedoms either grow or they die in those spaces. Systemic problems require equally methodical and equally funded solutions. So use your legal backgrounds to serve your communities in whatever role or capacity you can. And I've heard a recurring theme, we actually discussed it yesterday, about Black law students. My sister's a law professor, so we talk about it a lot. Black law students and imposter syndrome. So let's take a moment and just stomp on that one, okay? I need you all to commit to really thinking and then removing that from your brains. I'll talk quickly about it because I think of it as like a jacket that you're given, but you actually don't have to wear. You might be sent to represent whatever firm you end up in DEI conferences. That was my experience a lot in TV news, right? Got to be the face of that. You might be front-facing at on your company website during Black History Month and Women's History Month. And my strategy has been to embrace it. Embrace it. Then leverage it. Leverage the absolute crap out of it. Grace, I think, is giving yourself the perspective to turn what you think might be a bit of a burden into a privilege. You get to represent your race. You get to represent your gender. You get to represent your orientation. It is not a burden. I never think of it as a burden. It is a tool, and a tool in a bunch of tools in your arsenal that will allow you to think bigger and serve your future clients even better. Your approach, and you'll approach problems and problem solving differently, as your community problems have historically been different. And I think that's a gift. That's a gift. It's not a burden. And that is the dexterity, I think, in many ways, that you're going to need to find flexibility in laws that have remained inflexible. So, as you guys know, this group comes from UDC and Howard and TSU and Southern and FAMU and North Carolina Central, some of the best law schools in the country, and you are LexisNexis fellows. This is not luck. You did not happen into these positions. So we need to stomp out. That is the best ring ever. Oh my God. Don't be embarrassed. I don't even know who that was, but that was amazing. I need to change my ringtone. Like, I actually felt like I should step it up a little bit with that. Okay. And that means that I think you cannot cower in spaces that are sometimes actually set up to reduce you. And you will not be complicit in your own dimming. You can be amazing. And you're not an anomaly. You deserve to be here. So everybody, deep breath again. These presentations are you showing us your genius. Don't be nervous. We're rooting for you. We're excited for you. And you know so much more about this than we do. You deserve to be here. The clusters that are presenting today have mulled over, I was going to say endless hours of data, but that might be like an understatement. So I'm going to leave that part out of the welcome. The only statistic that I want to share is that in a country where Black people make up less than 14% of the country, we make up 40% almost of incarcerated citizens. Black lawyers make up 5% of the field. And so I don't list these statistics to depress you all, but to make you understand the need for this community. Opportunities like this fellowship at LexisNexis don't happen enough. The stats show that there's no place for belonging, frankly, if you don't go out there and just create it yourselves. So you have to continue to earn your place on those shoulders that you stand on. Get out there and create the employee resource groups. ERGs are an amazing way to connect and empower each other. But go a step further. Meet with the managing partners and boards and explain your findings and recommendations for more inclusive workspaces. Challenge the Alumni Association to mentor and sponsor the next generation. Pour into them because, as you know, a rising tide lifts all boats. You are going to be in boardrooms and in classrooms and in courtrooms where there are a lot of people who don't necessarily think like you. So what better reason is there to be there? No one's going to think like you necessarily. One relationship that I would like you to think about forging is a strong alliance with yourself, and not in the esoteric, like know thyself kind of way. I mean, specifically with the version of yourself. Connect with this person who still is young and has an ear to the ground, who understands the wills and the wants and the struggles of the average person. The why that keeps this version of you going still should be your why through your entire journey, even if we all sit down back here 20 years from now. This version of you can be easily lost. Maybe you're on the partner track and you can't do as much pro bono work as you want to. Or maybe you feel like, I don't have the time now to take the 1Ls out to lunch from your alma mater. But do it if you can. It's going to keep you centered. There will be class action cases that you feel empowered taking on big business. There'll be cases where the little guy gets the short end of the stick. When calling and career intersect, it will feel amazing. But when they seem to be drifting further apart, that's when you got to double down on both. It is an art, separating career from calling. But again, if you have an array of tools in your toolbox, you can do it. Lastly, I'd like to talk about lifelong learning. I recently produced a doc called The Rebellious Life of Mrs. Rosa Parks. It's actually streaming on Peacock right now, and it's the first full-length documentary on Rosa Parks. When someone said that, right, I say everybody's got this look like, what? Yes. In fact, when this project was first pitched to me, I was like, sure, I believe you, but let me Google that first to make sure. And it has been astonishing for me personally to learn a lot about a woman who I would swear to you I knew pretty much everything about her, and most that I thought I knew was not accurate. You have to be a lifelong learner. You're learning the law. Many laws don't change often, but over time, interpretation of the law can change. New meanings and new consequences are given to existing laws, and these changes have always affected people of color more. Understanding the law as it is will not serve the people of future. Mastery of the law, or anything really, doesn't elevate anyone to an enlightened status if their journey with learning is completed. It doesn't happen if you become a Supreme Court justice. It doesn't happen if you become an elected official or a journalist, not even if you're a rapper turned yesterday's billionaire. Structures and I know that was a dig. That was such a well-deserved dig, but listen, that should have happened when slavery was a choice. I was like, but I'm getting off topic. Let's carry on. Structures and institutions give the appearance that they are rigid and immovable. They are amorphous and bend just enough to keep things unjust at times without appearing to change. And so you have to be just as vigilant in your commitment to learning as the problems change and adapt so that you can organize and execute. There is always more to know, so much surface to cover. And when you cast the widest net you can cast, then go even deeper. And it is in the same spirit of lifelong learning that makes me very excited about today. Finding equity in the law, how the rule of law is essential to taking down systemic racism. Like, could there be a bigger task? Like, let's do something like tackling systemic racism. I just felt like that would be a nice, easy, you're students, right? That shouldn't be so hard. Just not how much time we're gonna give you guys, It is a daunting task, obviously. But I have seen the details of some of these reports, and there are real-world solutions that will be presented today, and they are remarkable. So I am honored to be here. A big thank you to the African Ancestry Network and Rule of Law Foundation at LexisNexis for this fellowship and this event this morning. Let us start by diving into some problems and, probably more importantly, some solutions. So, tense up, presenters. Here we go. You ready? Cluster 1 is going to kick us off, and I will take my seat here as I will be the moderator for the questions for each cluster. Thank you.
Good morning, everyone. I am pleased to be with you all this morning and to introduce my cluster. My name is Oyede Adebayo, and I am currently a 3L at Howard University School of Law. I am a part of Cluster 1, which is titled Equity for Youth in the Legal System, and my partner, Mikkel Brown, will discuss his part of this presentation later on today. My topic is on the inequitable application of the waiver to adult court system and its negative implications and impact on procedural justice for African American youths in the communities today. I pose a question for you all this morning. Do you know how many juveniles in your state are waived into the adult court system each year? Well, I know, because as part of my LexisNexis fellowship, I conducted research to look into the number of juveniles that are waived into the adult court system each year. And quite frankly, I am upset knowing the disproportionate number of African American juveniles who are transferred into the adult court system each year. So as you listen to my presentation today, I want you to think about the impact this has on procedural justice and how your advocacy for a change and a reduction in the number of Black youth who are transferred into the adult court system this year can help reduce the amount of Black youth. And with your advocacy, I know that a change can come. As I present to you today, I will first discuss the current waiver process. Next, I will go into the negative implications that occur because of today's waiver process. And finally, I will discuss the solution that I was able to create with the help of LexisNexis to solve this issue of a disproportionate number of Black youth in today's adult court systems. So to start, the waiver to adult court is a legal mechanism by which decision makers such as judges and prosecutors are able to waive juveniles into the adult court and allow them to be processed, tried, and sentenced as if they were adults. These decision makers, the judges and prosecutors, have high discretion when determining which juveniles to waive into the adult court and can also rely on a various amount of factors when determining who to waive into the adult court and the reasons for waiving them in. Some of these factors include the race and age of the juvenile, hot topics, public opinion, the type of crime that was committed, and even the location of the crime where it was committed. The issue of the high discretion decision makers have in determining who to waive and the varying factors that they are able to use when making these determinations has resulted in a disproportionate number of African American youth being waived into the adult court systems today. In fact, in 2018, of all the juveniles waived into the adult court in the United States, more than half of those juveniles were Black youth. And today, in each state, it is more likely for a Black youth to be waived into the adult court than their white counterparts who may have committed the exact same crime. After finding out about this truly troublesome impact of the waiver to adult court system today, with the help of LexisNexis, I was able to conduct research to look into the continued negative implications that occur because of the waiver system. And I found that the mere presence of a juvenile in an adult court significantly drives the likelihood of them being convicted because of the stigma that is attached to them the moment that they walk into a judge's adult courtroom. Judges seeing a juvenile in their courtroom makes them believe that because they are present in that court, they are deserving of being sentenced as an adult, regardless of their age. The stigma does not end with the higher conviction, but juveniles who are tried in an adult court are also more likely to have a higher sentence than they would have had they have been sentenced in a juvenile court. And it doesn't end there. The moment that a juvenile enters the adult prison system, the likelihood of recidivism skyrockets because their presence in an adult prison system takes them away from the rehabilitative programs that they would be offered if they had been processed in a juvenile court system. Not only do they get taken away from these rehabilitative programs, but they are also stripped away from the access to education that they would have had they not have been entered into the prison system or if they had been tried in a juvenile court. The lack of mentorship, guidance, and support to help these juveniles turn away from a life of crime is taken away from them and increases the recidivism rates. And quite frankly, a juvenile being in an adult prison system exposes them to hardened criminals who in turn may mentor them to continue committing crimes or let them know that this is the only life that is available for them. And because I don't believe this to be true, and I want the recidivism rates to decrease, and for us to encourage juveniles that they can turn away from a life of crime, I worked with LexisNexis as part of my fellowship to create a solution for this problem. And that solution is an analytics assessment. As you see here, this is a wireframe prototype of the court's disposition of waivers to adult court, which means the public would be able to see the number of waivers that judges approve of in that court system. Not only will they be able to see the amount of waivers that are processed, but they would also be able to see the demographics of those waivers. This could be used by public defenders when trying to make an argument to keep a juvenile in juvenile court by advocating and arguing that that court has a likelihood to apply standards unfairly, and because of this, they should err on the side of keeping a juvenile in juvenile court as opposed to transferring them into the adult court system. Additionally, this can be used for the public to help hold elected officials accountable for their actions and encourage them to make equitable decisions when determining which juveniles to waive and why to waive them in, because they know the public is aware of the decisions that they are making. As I close today, I am optimistic that this solution will reduce the number of Black youth who are in the prison systems today and who were transferred into the adult court. So what I want the audience to do is advocate for the Black youth in your communities, speak to the elected officials in your community, and contact your justice systems to help advocate for a change to the waiver system. And I know that you doing this will help reduce the number of Black youth who are transferred into the adult court systems today. Thank you. And now my partner, Mikkel Brown, will give us his lovely presentation.
Good. Oh, yeah, sure. I wouldn't want to mess anybody up.
Yeah, so I can take the ones that have gone through.
Here you go. Good morning, everybody. My name is Mikkel Brown. I'm a 3L student at Thurgood Marshall School of Law in Houston, Texas. Yes, absolutely. Thank you. I just want to say, Mama, I made it. I'm on the same stage with the Soledad O'Brien. And I'm so honored and very humbled to be here to talk to you all about the equity of law and systemic racism, an issue that is very important and dear to my heart because I have been affected by it. And today I want to speak with you about the school-to-prison pipeline and the discriminatory use of school discipline and how it affects minority students and how we can empower the students and empower ourselves to be advocates of social change. Before I start with the school-to-prison pipeline, I'd like to tell you a little bit about myself and my story and my journey to law school and how it relates to the school-to-prison pipeline. I'm born and raised in San Antonio, Texas. African Americans make up about 6% of the population. When I was 17, I was arrested for the first time. My charge was obstructing a passageway in a mall. At that time, 2 weeks before my 18th birthday, I went to the mall, River Center Mall, with 5 of my friends. Due to the increased gang activity and biases around that, I was stereotyped and the policy was that we could not walk in groups of 5 or more people. And so, being the advocate that I have always been, and using my voice, I advocated for my friends for us to exist in a public space without harassment. Well, a verbal conflict ensued, and at the end of that verbal conflict, I lost. I was handcuffed, told that I would learn my right to due process. Those are exact words. I was detained, marched down to a small office, and assaulted because I had a smart mouth. And that experience altered my way of thinking. Using my voice has been something that I've always loved doing. It's one of my greatest gifts. And in this instance, my voice, fighting for my rights and advocating, landed me in jail. But that did not end my journey. Thankfully, I have a strong, praying mother who hired an attorney, and we went to court. Now, my charges were dismissed before we hired the attorney, unbeknownst to us. However, what that process did was show me how to be an advocate and show me that there's a way to fight for justice. And we got a favorable outcome. But I was still deterred from becoming an advocate and going to law school. And sadly, for a lot of African Americans in America, this is their experience. They experience disproportionate discipline in schools, which results in a mistrust of the justice system and how it applies to them. And so that's why I want to talk to you today about the school-to-prison pipeline. Thank you. So let's talk about it. Discipline discrimination takes shape in many different forms. In school, it takes place in the shape of exclusionary actions such as expulsions and suspensions. African American students are 3 times more likely to be expelled or suspended than their counterparts. Nationally, Black African American students lost 66 days of instruction compared to just 14 days of their counterparts. This is valuable time and valuable lessons that they are missing out on in social interactions needed to be a prosperous person in society. Additionally, another example would be in Bryan, Texas, where African American students make up less than 25% of the students in the district, but account for more than 52% of all Class C misdemeanor citation tickets. They are missing out on very important instructional time to go to court, which causes delinquency, and as we will discuss later, leads to the pipeline to prison. Suspension and expulsion is not the only types of discipline Black people are experiencing at disproportionate rates. We also experience citations and referrals to police officers, which has been a growing occurrence in school districts. The administration of discipline has changed in the last couple of years. In the beginning of the public school systems, our teachers and our principals were in charge of administering the discipline, right? You would have a counselor, you would maybe get your mother called. That has totally changed because of the increase in school shootings and violence and gang activity. And the role of police officers has changed. What is known as a school resource officer is just a police officer, the same gun and the same badge and the same arresting authority, but in a school. What I didn't tell you earlier about my situation in San Antonio the first time I was arrested was that this was a school resource officer working off-duty security at the mall. So that means that he was taking his same biasness and his same stereotypical attitude and administering what he thought was justice in a school district in San Antonio. And needless to say, he was not fired, or this did not change him, change his perspective, from my experience. What you see on the screen now is a visual for the school-to-prison pipeline. So first, it starts with exclusionary school discipline, suspensions, expulsions, and referrals and citations, which then leads them to the first introduction of the court system, oftentimes for African Americans. They're introduced to the court system at school. From there, starts a pattern of delinquency, from missing school to go to court, having different classes that they may have to take outside of their court sentencing, and then finally dropping out of school, which makes them miss highly important instructional classroom time. From there, they are missing the time that is needed to develop as a person in society, and then actual mistrust and lack of good faith forms in their physical impressions of the community. Then actual criminal conduct occurs and criminalization. And as we just heard, the likelihood that they will offend again is increased because of the lack of opportunities. And so it's important that we advocate to end this school-to-prison pipeline for children, especially African American children. So now I want to empower you as much as I have been empowered through this fellowship. As an advocate, I've always used my voice, and I want you to use your voice, because studies have shown that restorative justice programs and initiatives and counseling services reduce the school-to-prison pipeline and decrease criminalization. And so what I've created is a juvenile justice toolkit. In this toolkit, you will find resources needed to advocate for change. And I want you to use this kit and improve this kit and talk to your clients about this kit. You'll find this kit on the social resource justice page, on the practical guidance page at LexisNexis. And with this kit, I want you to feel empowered to create programs and initiatives to end the school-to-prison pipeline. Thank you very much. Yes.
To answer some questions. Oh, thank you, if I may. So you mentioned that the school-to-prison pipeline sort of had an impact on your eventual path to going to law school. Can you talk a little bit about that intersection, how those two things are actually correlated?
Absolutely. So with that incident with that police officer and my introduction to the criminal justice system, I just completely... I personally just lost faith in the way that justice was applied to me. I saw that being an advocate did you nothing good. It got you in trouble, as a matter of fact. And I realized that, I want nothing to do with this system. It's unjust. It's not fair. And from my mother having to miss work to hiring an attorney who, quite honestly, didn't really have to do much at that time because the case was dismissed before I even had a court date for a lack of evidence. So we show up to court, 5 minutes in, we're out because the case was dismissed. And so I looked at the attorney as also being part of this same system and corrupt. And I think that delayed my decision to go to law school. As you mentioned earlier when you discussed the development of mistrust in our system, that's exactly what happened to me. And I no longer wanted to be a part of it, even though this is exactly where I need to be to impact the change.
You mentioned, and you showed us your resource kit. Who's the audience for that? And you sort of opened it up for all of us to empower us, but how do you think it's going to be used specifically? And who's the one who should say, now that I have this resource kit, that changes my ability to do X?
Initially in this project, it started out for teachers and school principals and administrators, but then I realized who the LexisNexis client is, right? And that's firms and advocate associations, maybe even ACLU. And so I realized that this kit is actually for advocates and attorneys who are at that intersection of being an advocate and an activist. One of my professors has said that there's a difference between the two. You can't be an advocate and a real social change activist, because activists don't necessarily prescribe to the rule of law, whereas advocates, attorneys, prescribe to the rules of law and describe the rules of law. And so there's two different types of ways of approaching equality, but you can do both. And this toolkit is for you as an advocate. It helps you find case law, treatises, some reform information on restorative justice, maybe something that you haven't heard before, and it puts it in one place to make it easily accessible for you.
If I gave you a big old bag of money, $1 million, that's a nice round number, what would you do with it first to start having a real impact on ending the school to prison pipeline?
Well, because of the increase in SROs, school resource officers, and the growing of school districts having their own independent police departments, actually, I think I would start with training, sensitivity training, bias training, and also develop programs. One of my ideas was to develop a pipeline to law school for students who have never seen an attorney until they were arrested. So I think that that's important. So that's what I urge you all to do, is find someone to mentor and bring up and show them the way.
What would the impact be if, in fact, we were able to end the school to prison pipeline?
I think that we would see an increase in Black people interested in legal education and going to law school. Again, for me, it was just a loss of good faith in this system, and I wanted nothing to do with it. But again, this is where I need to be in order to make the change. And so I think helping do that will increase the number of Black attorneys.
What kind of impact do you think it would have on removing people who eventually make their way into the criminal justice system? As you mentioned, right, what used to be, when I was in high school, a kid punching another kid, that's bad, but not assault one, which it would now become, and that really changes the game and puts people into the system. What kind of an impact would you guess that would have if you could end the school to prison pipeline on what criminal justice and incarceration looks like today?
I think that's what equity in the legal system looks like, exactly what we're here to talk about. It's not that I want more people to get arrested that are not Black. I just want the same rules to apply to us all equally. And the statistics are there that show that they don't.
You started your presentation with your personal story. What was most surprising to you as you were moving through your research? Was there anything that you didn't know because of your personal background?
It's nothing that I didn't know, honestly, as a Black person experiencing life in America. But what was staggering to find out is that this is happening all over America, in every city. And it's growing, and it's only going to grow because the number of school resource officers is only going to grow with the increased violence in schools.
Mikhail, thank you very much. A round of applause.
Thank you.
When people talk about the changes to the criminal justice and everyone in this room knows this already, a lot of the pushback comes from folks who say, well, I'm representing the victims, and I'm representing somebody who has suffered through a violent crime. How would you think about what you're proposing with sort of that pushback? Is there a way to balance the rights of victims and also what the changes that you're proposing to this juvenile process?
So I believe that victims' rights, of course, are important, but I also think we need to think about the youth who are transferred into the adult prison systems and are treated as if they are adults for the crimes that they committed, even if they committed them at, let's say, 14. I think it's important to, of course, provide victims with the remediation that they deserve, but to also look at the juvenile who committed it and try to understand why they may have committed such acts. I'm not advocating for juveniles to stop being punished for their crimes, but more so I'm advocating for them to stop being punished for their crimes as if they were an adult, and to keep them in the juvenile systems, which would provide for them the rehabilitative programs that could help them to stop committing such crimes.
You mentioned, you ticked off a list of discretionary factors. One that surprised me was just the geographic location. What kinds of these
I think that the court should also look at personal factors when it comes to determining which juveniles to waive. Such factors may include their community involvement, their involvement in school, good grades, having a strong religious background, and also a strong family structure, and even possibly a job. Things like this could help deter a juvenile from committing that crime again. And many times, some juveniles simply committed that crime because of being influenced by people they were around. But if we're given a second chance to make a change, I know for sure that many of them would if they were given the chance to.
A lot of your data is really around transparency. I'm always curious as a reporter how you change the narrative, because as you say, you show up in court as a juvenile being charged as an adult already. The story has sort of been written. How do you think your research and your work translates into helping people shift their narrative around these juveniles in court?
I think that Black youth in general in America are already stigmatized and looked upon as criminals, and knowing that this stigma that is already attached to a Black youth, being aware of the number of Black youth who are transferred into the adult court systems would provide transparency of the public to be aware of what is going on in their criminal justice systems, and would help them to be able to advocate for the Black youth who are being stigmatized and transferred into these prison systems, to allow them to get the help that they need, while also making sure that, of course, victims get their rights and their day in court.
This is a bit of a follow-up to that. So how do you think specifically this transparency, which I think is really remarkable in what you're presenting, would actually trickle down to make changes in the waiver system?
So first, one of the groups that could use this waiver system would be public defenders who are making a case to keep a juvenile within the juvenile system. I believe that having more public defenders and the public being aware of the way that the courts waive and the amount of juveniles that they do waive into the adult court will encourage the judges to think about other factors that they should use when determining who to waive, and even let them know about their own biases that may be occurring in their court system that they may have not been aware of until looking at this analytics assessment we have developed.
You mentioned use by the general public as well. How do you see that happening? And I mention that because I feel like we're in an age of maybe too much information sometimes, lots of misinformation and disinformation. How do you empower, how do you see that working out where the general public is empowered in some capacity? Could you walk us through that?
Mm-hmm. I think that a lot of people in this country are aware of the rate of African Americans who are shoveled into the prison systems today, and particularly mothers and fathers who have sons and daughters who could be targeted in today's criminal justice system. I believe this would be for those parents who want to make sure that their child gets their day in court and are not treated with stigmas because of their child being a Black youth. I think they would be able to use it to advocate for their child in the event that they are found in the prison system and are capable or are possibly going to be transferred into the adult prison systems. So I believe that this will cater towards the parents of those whose children are at risk of being transferred to adult court, and also general public who may not have kids but are passionate about juvenile justice like myself.
Excellent. And the same question that I asked Mikkel, I'm curious, was there a moment where you were surprised by your research, or that you sort of turned a different direction because of something that you were learning and understanding?
I think I was surprised to hear about the ages of which a juvenile can be transferred to adult court. In some states, I found it could be as low as 13 and 14, and to me that is significant. I have a little brother myself, so just thinking about him at 13 or 14, being within an adult prison system with 40 to 60-year-old criminals is just astounding to me, because I believe at 14 your brain is not developed enough to know right from wrong, and you do have a possibility of making changes to the life that you currently have. So keeping them in an adult prison system and allowing them to continue living that life of crime because of their placement in an adult prison system is something that I wanted to change and something that I was shocked to see.
Oye, excellent presentation. Thank you so much. Can I get another round of applause for our first cohort? Thank you both. You bet. Thank you. Great presentation. I'm going to invite our second cohort to come on up. I should mention that this cluster, Cluster 2, is diversity equity and inclusion in legal education.
Good morning. It's wonderful to see everybody here today. My name is Rhea Ramsey, and I am a large markets regional manager and a mentor in the fellowship. As you know, we need some diversity in the legal field, and the key to that is by increasing access to legal education. But we also know that systematic racism resides in the legal profession through multiple barriers, through law school and a legal education. The numbers speak for themselves. 13% of African Americans make up the US population. 5.9% of attorneys are African American. 2, since 1983, almost 40 years, Black representation in the legal profession has only grown 2%. 143, the average score of African American LSAT test takers is 143, and a minimum of 145 is required for most law schools. So, if we continue the same path of the past, diversity will not truly be achieved in the legal profession. As a result, we've developed 2 programs in 2021 to address the gap to access to legal education. First, we started through the inaugural fellowship, and with the fellow Paris Mullet of the Texas Southern University Thurgood Marshall School of Law, who proposed and designed the Blueprint program, which conceived to increase diversity in the legal field while providing support, coaching, mentoring, and resources to minority and first-generation law students. And this support would occur from the pre-law application through succeeding in law school to graduating and passing the bar to join the industry as practicing attorneys. Then we realized we needed to start earlier than that, and perhaps in primary education in minority communities. As a result, the LexisNexis African Ancestry Network Raleigh chapter and the Legal Kids Foundation partnered to develop an interactive curriculum for the Southeast Raleigh Elementary School, focusing on the rule of law, legal rights, and careers in the legal industry. The children in their early formative years engaged in role plays, workshops, STEM exercises, and even a mock trial, where volunteers from the African Ancestry Network, the North Carolina Central University Law School, and local high schoolers in STEM programs simulated a trial, passing of legislation, as well as gave exposure to the rule of law and the legal profession through local judges and attorneys. But this was just the beginning. We learned that we needed to do more in this space, reaching students not only in elementary school, but middle school, high school, college, and within law school. This cluster will walk you through how we continue to increase diversity, equality, and inclusion in the legal education by engaging with students throughout their primary, secondary, and post-secondary educational experience. So now I'll hand it off to Maggie. Thank you.
Good morning, everyone. My name is Maggie Huffman, and I'm a senior product manager at LexisNexis. And I'm also the proud mentor of fellow Dominique Douglas. Unfortunately, Dominique could not be with us today, but I am delighted to share her project. Focused on the legal education space, Dominique's project seeks to teach children of the elementary school age about important legal concepts. And I present to you all the Gavel League. The Gavel League is a mobile application framed as a game that helps to teach students at the elementary age important legal concepts. The Gavel League immerses students in a real-life scenario. In our prototype, we're focused on Miranda rights. So the Gavel League will teach the student what to do in certain scenarios that they might find themselves in their everyday life. In our prototype, the Gavel League finds the student in their apartment. As they're navigating through their apartment, they can come across a book to help teach them some of the Miranda rights key concepts, and they hear a knock at the door. Their grandmother asks them to answer it, and when they answer the door, it's a police officer. And as the police officer asks them questions, the child is presented with multiple choices. one being their best option and one being an incorrect option. And the student then can choose an answer, and they receive the feedback on their answer and then can move on to explore other areas of this universe. And I invite you all to scan our QR code so you can play the Gavel League yourself and experience this exciting game that will help to teach elementary school students important legal concepts for their everyday life in a fun, engaging way. Thank you all, and now I'll turn it over to Sango.
Thank you, Maggie, for that great presentation. And we don't just stop with legal primary education. Good morning. My name is Sango Wawa, and my mentor is Rhea Ramsey. As many of us know, there's a lack of diversity and representation in the legal field. One solution is early intervention with education and mentorship about the legal field for minority and disadvantaged students. During my fellowship, I leveraged Lexis products like Lexis Plus to uncover the barriers associated with minority and disadvantaged students' access to the legal field. Thus, my fellowship proposal was called the 10-Year Plan to the Bar, also known as T-Bar. The purpose of T-Bar is to jumpstart high school students into the legal field by providing them tools, resources, and mentorship about the legal field throughout their journey to the bar. As a result, T-Bar participants will be prepared to alleviate the effects of systemic racism by increasing representation in the legal field by 10%. So step one, high school. The goal in this step is to create competitive and financially prepared applicants for college. Yes, and that's my daughter in the back.
She's saying, go, mommy, go.
Thus, from freshman year to junior year, high school students will enroll in TRIO Upward Bound at their school. TRIO Upward Bound is a federally funded nationwide program across the United States that helps students access to college. T-Bar builds on TRIO Upward Bound by offering a specific career path after high school. Thus, TRIO students will submit an application and pre-assessment form for entry into T-Bar. Once enrolled in T-Bar, T-Bar participants will get access to assistance with standardized testing, resumes, reviewing essays, the various types of scholarships available to them, coaching on the FAFSA, Loan 101, and all things repayment. Knowledge that many of us as first-generation law students and attorneys did not have. So step two, undergraduate. The goal in this step is to help T-Bar participants achieve and maintain academic success throughout college. Thus, during their first and second and third year in college, T-Bar participants will be encouraged to not only keep and maintain a 3.0 GPA, but also enroll in pre-law fraternities on their campus, review the various programs offered by the Council of Legal Education Opportunity, apply for as many scholarships as possible, and gain practical experience. Finally, in their fourth year, T-Bar participants will be encouraged to take as many practice LSATs as possible, learn about the nuances of law school applications, and have tips and tricks from their T-Bar mentors. And finally, submit a post-assessment survey for us to track their progress. So step three, law school and beyond. The goal in this step is to help T-Bar participants graduate law school with a job and sit for the summer bar. Thus, in 1L and 2L year, T-Bar participants will be encouraged to visit the Writing Center and Career Hub as frequently as possible to prepare for on-campus hiring each year. Moreover, T-Bar participants will be encouraged to apply for as many scholarships and fellowships as possible, like the fellowship I'm currently benefiting from. Finally, T-Bar participants will be encouraged to review and understand all the various opportunities available to them in the career field. For instance, judicial clerkships, public interest focused work, and like Lexis, alternative legal careers. And then their 3L year, networking and bar prep. Now, this is just a small taste of the TED Talk-like experience T-Bar participants will have gained throughout their journey to the bar. Would you please play the video for me?
Honestly, it wasn't that I didn't think I could attain it. It didn't seem accessible. It wasn't. I didn't grow up around any lawyers. It wasn't on my radar in that way.
Well, my reasons were sort of inherited, if you will. I came to America when I was 8 years old from Ghana.
A 5-year Army veteran, a bachelor's degree, and a Juris Doctorate degree. If I can make that happen and father 3 kids, and now get to see those same children. 2 of them are going off to college now.
People who do this every year. They graduate from law school every year. They take the bar every year. They become licensed attorneys every year. What's so special about them that I don't have? And you'll find if you really think about it, the answer is nothing.
It doesn't matter where you come from. Whether you come from parents that suffer from addictions or low income or immigrants, or you feel like maybe no one went to college, no one graduated high school. If that's not what you want, don't look at your past circumstances. That just happens to be what you came from. That doesn't mean that's where you're going. You can achieve anything that you want to achieve. You just have to put your mind to it. And would you go to the next slide for me, please? So what can you do? Don't be the gatekeeper. Be the key. Stay involved. Give back. Thank you for your time this morning, and now I'll pass the legal education baton to my colleague, Alexis McNeil.
All right, so good morning, everybody. Now, it appears that in the middle of the night, somebody tried to come and steal my voice. That is okay. Thank you. That is all right. So I want to start off this morning by talking about a man named Langston Hughes, right? And in 1925, Langston Hughes wrote a poem entitled I Too. It goes, I too sing America. I am the darker brother. They send me to eat in the kitchen when company comes, but I laugh, and I eat well, and grow strong. Tomorrow I'll be at the table when company comes, and no one will dare say to me, go to the kitchen then. Besides, they'll see how beautiful I am and be ashamed. I too am America. So, as song goes noted, my name is Alexis McNeil. I am a 3L at UDC David A. Clark School of Law. And believe it or not, I too am America. So the America that we see today is actually the result of 2 very different histories. Now, one begins with English settlers in 1607. The other begins with enslaved Africans in 1619. Both happened right up the road in Virginia. Now, today we're going to actually talk about the vein that stems from the enslaved Africans. Now, these enslaved Africans have provided this country with labor that's created industries, talent that's entertained generations, and then also undeniable flavor in this melting pot that we call America. However, it appears that a lot of times that history is reduced down to slavery, civil rights, and a single black president. Now, while that may seem like, oh, it's okay, that's our history, it's not, and that's unfortunate. Now, we deny ourselves so many different colorful stories and brilliant minds, important issues, and forgotten histories remain untold. Now, while the stories from the browner side, oh no, thank you. I don't know why that's going. No. So, while the stories from the browner side of America exist, they're rarely viewed And that is an issue because it suppresses that second vein of American history further. But thankfully, all of this has been recorded, right? And it can be viewed through the law. Now, the law is a very special area because it is an actual literal snapshot at any given point in time. So, the cases that you read are real people with real stories, and they've been collected since the founding of this nation. Now, as you see in this photo, excuse me, but some of the cases that we do talk about, they are usually found in case books, right? And for those unfamiliar, a case book is a horrible, no, I'm just kidding. A case book is a case book is actually a legal textbooks that we use in law schools that teach us the legal concepts, but then also they provide cases sometimes to give a practical example of those actual concepts, right? So they are amazing. However, those cases contained in the case books are often dominated by a white American focus, which inherently assigns the white perspective as objective. Now, what that looks like is, for all the lawyers and law students in the room, something like a reasonable person standard. So a reasonable person standard is a deciding factor in many, crimes. And everybody knows that that reasonable person is really the lens of a white male. Now, that is an issue because as you see in this photo here, minorities and minority students are often asked to abandon their own life experiences to participate in and further understand that objective court reasonings, even if those reasonings contribute to their own systemic suffering. Now, here's the good part, the solution. So, to combat this, I've proposed the creation of a repository of African American centered cases that span various areas of law on the LexisNexis platform, which will allow legal advocates, professors, students, and legal editors the ability to find cases and thereby find the stories that shed light on America's second history. Now, if you all be directed to the screen, this is actually a live demonstration of what this looks like on a LexisNexis site. So as you see here, this would be the repository, which can be accessed through LexisNexis. You will go on we can start the video, please. Thank you. So you will go under the Social Justice Resource tab, and from there, users will be given access to the racially diverse content collection, which you just saw. Now that contains cases and secondary sources, but it also includes that over there, which is the Law 360 News, which provides a real-time view of legal issues that are happening right now. So, further, the users are able to narrow the search options usually available for harder to find cases. But the distinguishing feature here is that there's already an embedded search term in all of the cases that you pull up. So if you do type in something like adverse possession, which I did there, the cases that come up are only cases that relate to African Americans, African American history. So what could this mean for legal education? I'll tell you. A LexisNexis repository of racially diverse cases. Sorry. I'm going the wrong way. I'm sorry, everybody. So, the LexisNexis repository of racially diverse cases provides resources to create textbooks and treatises that will provide students with records of minority achievement, untold histories, and then further a secondary education. Now, to talk further about that secondary education, that secondary education will focus on African Americans for the purpose of discussion and review in legal classrooms across the country. This means students will be able to not only learn those relevant legal issues, but they'll also receive a beneficial cultural exposure at the same time. So as you see here on the screen again, you have a situation where if a professor teaches adverse possession and property law, and we have that case that explains that legal concept, I've included the case Antonio Proctor just for an example. And in Antonio Proctor, this is a real case, by the way. Antonio Proctor is a free black man in the United States of America in the 1800s. Now, he was provided 185 acres of land by the Spanish government for his participation in the Spanish militia. So, when America obtained Florida, because it was in Florida, but when America obtained Florida, Mr. Proctor sought to have his land recognized as his and went to claim the title. Now, he provided the original land grant survey, which is that small picture way up there on the left, and some additional information. And in the end, he was granted and confirmed that title or claim of title in 1824, right? But there's also another interesting feature about casebooks, and that is the fact that sometimes after cases you have what's called the postscript, which you'll see in black. Don't worry, I got it big for you, right? So postscripts in casebooks are sometimes included, and they provide additional context to the case as well as additional facts about what occurred after, before, during that time period. So in this particular postscript, it talks about Mr. Proctor's life, the land, his children, and so many other things that occurred after this actual case. So as you see, teaching from this particular case opinion and similar ones would educate students not only about land grant survey or land grants, but it'll also provide that secondary education, which uncovers pieces of American history from the brown side, which often gets, or seldom gets, discussed. So, in that, I propose essentially creating culturally aware advocates. Now, as you have heard already, there are only 5% of the lawyers are African American in this country. However, 100% of lawyers in this country do have to go to law school. So, by creating cultural competency and professional development, we can mitigate and eventually eliminate systemic racism in the legal profession. Now, this competency can be achieved through exposure in legal education, by increasing attention to the distinguished relationship between Black Americans and the American legal system. So, to this end, the LexisNexis repository of racially diverse case law will help increase that awareness of minority culture and help to mitigate these issues that we find ourselves seeing all the time. So now you all have heard me speak and you see why this is so important to me and how it can be beneficial to all. Therefore, it's my hope that you all will actually utilize that resource to educate yourselves, right? And by educating yourselves, hopefully, we get to that point where Langston Hughes's writings may finally be right, and you all will see that we all are to America. Thank you.
Excellent presentations. Can I have you stay at the microphone? And I know your voice is going fast, so I'll ask you the first questions and we'll keep it tight for you. I've always thought the reasonable standard, the reasonable person standard was this tricky thing, right? Because of course, who gets to count as the reasonable person? How do you think what you're proposing helps really shift that? Because to some degree, I feel it's so embedded, not just in the law, but in everybody who intersects with the law at some point.
So the reasonable person standard in which you ask about is one of the reasons why I actually originally thought of this idea. And as a 3L student now, my first year, you have to take criminal law, criminal procedure, these things. And in doing that, I would read cases that some people would get convicted, and I thought that made sense to me. Their actions made sense to me. I don't understand why you don't understand why they did what they did, right? And so when you create culturally aware advocates, what you essentially allow is for other people to also understand that that one way of doing things, that reasonable way of doing things as the law describes, may not necessarily be the only way to do things, right? And so again, by educating advocates, we will be able to create professionals in the legal field that in the future will be able to decide these cases, decide the future with a new mindset.
How do you, and I'm not a lawyer, so this question might just reveal my ignorance. I want to be a lawyer.
I'm not
After
a lawyer.
these presentations, I'm like, I am going to law school, darn it. How do you get people to, how do you make them, are there ways to incentivize them to pick these case studies that are more diverse? Or is it completely something that is up to the professor as you're teaching the class? Like, how do you incentivize them to say, actually, I'm going to start thinking about different cases as I educate my students?
That is a great question.
Oh, see? Law school, I'm telling you.
Also, I'm not a lawyer yet either. Give me 6 months, though. I'll be there. But to answer that question, you don't need to, right? You don't need to convince anybody to do what's right. And further, one of the things that we have been able to do here with LexisNexis is that a lot of people have volunteered to also help me find these cases, to help me, with this research. And we all come back with the same conclusion. It's very difficult to find cases about African Americans because the history is really getting lost, right? But in finding these things and having to go down the deepest tunnels, the enthusiasm is naturally there. Again, this creates a repository of cases where you are able to find those untold stories. They are fascinating, right? They are really, really fascinating. They touch all topics, whether it be business. Say, for instance, you have a case about a guy named S.B. Fuller, fantastic businessman in American history, happens to be black. Probably never heard of him in your life. That's okay. In one of the cases, he sues another company called the Fuller Brush Company, into which that company, they say, oh, you have my name, okay, fine. But in it, they go down a list of all of the ways in which this black man has created this entire network of salespeople across the United States of America, and how they have been able to create millions of dollars of revenue. And then you also find that S.B. Fuller is personally responsible for creating the leaders that we know today, like the Johnson Publishing Company, who's responsible for Ebony and Jet and other magazines. Also people like Dudley, who's responsible for one of the only black-owned hair companies, and so many others. So you don't have to convince anybody. Once you see it, I guess I told y'all we had a flavor here. So once you see it, you convince yourself.
Excellent, thank you.
That's no problem.
Sangu, can I bring you up to the microphone for a second? Excellent presentation. On your presentation about T-Bar, Give us a sense of what other programs exist, and where does T-Bar fall into that list, if there, maybe list is too strong of a word, of the programs that are already out there?
Yeah. Thank you for the question. So currently, one of the programs out there for high school students is Trio Upward Bound, and that provides high school students resources to get to college. T-Bar fits in that by allowing and having a specific career after high school. A lot of the times when you graduate high school, it's go to college, but you have to figure out what is it that you actually want to do? How do I get to law school? What do I need to do to be able to take that? And then once you reach college, there's another program called the Council of Legal Education Opportunity. However, that's geared to undergraduate students. So T-Bar sees that, okay, we have Trio, we have Let's Go to College, we have Clio, which is, okay, let's get you from undergrad to law school. But how about when you're in high school and you want to start preparing? A lot of times in undergraduate, that's when you start taking loans. That's when you're trying to navigate your own social self and figure out what is it that I want to do with your life. And then finally, at least in my case, I didn't necessarily know I wanted to go to law school until I graduated in undergrad. And then I had to figure out between navigating, okay, I'm graduating, how can I get to law school? Oh, there's a practice LSAT, there's this, there's that. T-Bar fits by giving you those resources before you step foot in college to give you the best starting foot for long-term success into the legal field.
A lot of what you mentioned is very strategic and tactical and practical, but I know a lot of what minority students deal with is around imposter syndrome. Mm-hmm. What does T-Bar do on that front? That it feels sort of as squishier than a lot of the tactics that you're talking about.
Yes. So one of the best parts about T-Bar is going to be the mentors there. So the mentors come from backgrounds where we all feel like imposter syndromes. For instance, you saw in the video, we had Pearl Mansu, who was actually a fellow last year. She came here from Ghana. We have Herb Brown, who's actually in the audience. He was in the military. He has children. I myself had my daughter throughout law school. My father was an immigrant from Congo. My mom was the youngest of 10 kids from New Jersey. Both my parents were in the military. I understand what it's like to not feel welcome. And I want to let high school students know I don't care what you look like. I want to let you know you can be here because I am here today.
Excellent answer. Thank you very much. I'd love to ask a question about our first two presentations about one of the things my sister, who's a professor at BU School of Law, talks about a lot is pushback around diversity. So first, let's talk about affirmative action and the Supreme Court. How does what might happen in the Supreme Court impact potentially what you've been presenting, do you think?
Yeah, so I think in terms of the Gavelly, that we could very much see that becoming part of the curriculum. Because the idea is that we're taking real life scenarios and things that children could encounter either then in their lives or later in their lives, and bringing that into an educational space that's fun for them, that keeps their attention, that is giving them a good way to learn and retain the information. So I would see that these current events and things that are happening in the world could be built in as modules in the Gavelly.
My sister has described when she has tried to get together groups of specifically black students, that there have been efforts to sort of say, well, let's talk about diversity. Let's make that discussion about diversity, which then she has found a lot of the conversations that are specific and particular to African Americans kind of get lost because diversity becomes this sort of big overarching topic, and I think it can be uncomfortable for people to ask specific questions or talk about their fears directly. Are there ways in which you have experienced that or you're seeing that, and how can these programs affect that, do you think?
Yeah, so part of Dominique's vision in this game is that, one, that the students could see themselves in this game in sort of a Fortnite immersive type experience where they could even start by creating their own avatar and create someone who models them and who they see, but that we're also teaching them these concepts in a really fun way. So things that might be really difficult to speak about one-on-one or in groups or with adults even is something that they can see in just their natural environment, right? Where kids are using a game and they might be playing with it and using it at school in a more lighthearted way, but that is tackling things that they very much might see in their real life.
These were excellent presentations. Thank you very much. I appreciate it.
Thank you.
Donna, I'd like to take a break. Is that okay? And we'll pick up with a third one next after the short break. Yeah. So we're going to take a short break, and we'll pick up with our next presentation right after the break. Our Cluster 3 presentation, which looks at diversity in leadership of the legal profession. Welcome.
Good morning, everyone.
Good morning.
My name is Nicole Ondano. I am a 3L law student at Florida A&M University College of Law. I am here today to present a pipeline, 3 pipelines, with my fellow cohorts, Ms. Christina Hall and Ms. Joanne Lewis. Our pipelines are dedicated to furthering diversity and inclusion in the legal profession. So before I start, I want to tell you a personal story about myself. I am a first-generation Latina law student. I come from no legal background, no legal connections. I did work as a paralegal before I commenced law school for 7 years, and I was told over and over again by all the attorneys that I worked for that it would be really easy for me to find an internship, that it would be really easy for me to find a job after law school. I quickly learned that my experience would be different. So that is why I'm so dedicated and motivated for my pipeline and to introduce internships to all HBCU students. We're going to talk about statistics today. Through my research, through my LexisNexis fellowship, we conducted research, and it showed that 28% of legal associates were minorities. Of that 28%, 12.5% achieved non-equity legal partnership, 10% achieved equity legal partnership, and Black and Latina women accounted for less than 1% of that. So why is this important? Why do we need a pipeline to offer internships for HBCU students? Well, my pipeline the solutions that my pipeline brings is it wants to increase workplace diversity. It wants to increase the underrepresentation of minorities in the top area of the legal fields, and by assisting to remove barriers to entry to these HBCU students. My pipeline it's in 3 stages, broken down in 3 stages. The first stage is recruitment. In the recruitment process, we're recruiting top law firms, corporations, law students who want to increase their diversity, who want to include these internships. After we have that law student and we have those recruitments, we go with the mentoring process. So we match them with a mentor, and we do reinforcement professional development. That professional development can come from resume building skills, mock interviews, blue booking skills, writing skills, anything within that sort, so we can secure and obtain that internship for that law student. Our ultimate and last stage, of course, is to secure and obtain that internship for that HBCU student. Lastly, I leave you with this. I challenge you that if you are as passionate as I am about this and you want to increase workplace diversity and you are in the position to do so, or you know somebody who is in the position to do so, please reach out to an HBCU, a local HBCU, all HBCUs, or LexisNexis. See how you can help get into the pipeline. See what internships you can offer HBCU students. Be the breakthrough. Thank you. I now introduce you with my colleague, Ms. Christina Hall.
Thank you, Nicole, for that introduction. As Nicole said, my name is Christina Hall, and I am a 3L at Thurgood Marshall School of Law at Texas Southern University in Houston, Texas. Thank you. Similar to Nicole, I'm going to start off by talking a little bit about myself and what motivated me to create this pipeline. When I decided to go back to law school as a non-traditional student, I had 3 main goals. My first goal was to graduate from an HBCU. My second goal was to clerk after graduation. And then my third goal was to return to big law, in which I had left to go to law school. However, I realized very quickly that those goals would be harder for me to obtain as a Black woman going to an HBCU compared to her white counterparts at predominantly white institutions. And although this is true for a multitude of reasons, one of the reasons that I was most invested and motivated to figure out why and whether this was an indication of anything was if this had anything to do with the lack of diversity currently on the bench. So speaking of the lack of diversity on the bench, I want to talk to you about the stats. So we'll start with the U.S. Supreme Court. Out of 116 justices in America's history, all but 9 have been white men. Out of those 9, all but 4, only 4 have been people of color, making up a meager a little more than 2% of U.S. Chief Justices being people of color. Now going down to the federal judges in the district courts, in the circuit courts. Only 11% of all federal judges identify as having some African ancestry. Lastly, looking at the clerks, in 2019, out of the 3,100 clerks, graduates that had the pleasure of obtaining a clerkship, only 20% were people of color. And out of that 20%, only 4.1% were Black or African American. Now you might be asking yourself, well, what's the correlation? Like, why does this matter? Well, the correlation is this. For out of those 1,500 federal judges that sit on the district and circuit court, 43% of those judges have a history of clerking. And so having a clerkship can significantly improve the likelihood that an attorney can be appointed to the federal bench. Hence my name, A Pipeline to the Federal Bench. However, when only 20% of all clerks are people of color and only 4% are Black or African Americans, the lack of diversity will continue to persist. Now, why a pipeline? Why is diversity important on the bench? Well, diversity on the bench confers legitimacy in the judiciary process. And it also instills a sense of trust in the process. A lot of my cohorts talked about this sense of trust and losing trust. When you see someone that looks like yourself, you have trust in the process. Lastly, it has real-life implications, and Alexis so eloquently described this in the reasonable person standard. When this standard is given or implemented by generally white, cis, affluent men, the standard cannot help but to be skewed in one way. So armed with all of this information through my LexisNexis fellowship, and also having conversations with judges and both federal and state, as well as past clerks, I realized that I wanted to be the change, and I wanted to increase the amount of applicants in the application pool for clerkship. And I wanted to do that by creating a pipeline. The pipeline that I wanted to create would have 3 stages. The first stage would be the skill stage, in which we would sharpen and hone those tools that a lot of us 1L students have learned, that is writing, researching, editing, blue booking, and that can make you a more successful clerk. The second skill is, the second stage is mentorship and internship. At this stage, the participant of the pipeline would receive a mentor to help them, guide them through the process of not only being a 1L student to ensure that they get those grades, but also in the application process when applying for the internship, in which they would get an intern with a federal judge for the summer. The last process is the application, which would be a virtual summit. And in this stage, we would walk the participants through actually applying for a clerkship. We will also equip the participants with a timeline to make sure that their application is both timely and competitive. So as I wrap up my discussion with you all, I want to leave you with this. I want you to think of the joy and the pride that you felt when Justice Jackson was appointed. And I want you to know that Justice Jackson's journey to the U.S. Supreme Court started as her being a clerk after law school. And I hope that that makes you engage your community to help me have this pipeline come into fruition. I thank you for your time, and I want to pass it off to my lovely cohort, Ms. Joanne.
Good morning. Hopefully it's still morning. Trying to work this clicker. Okay, there you go. Good morning, everyone. I am so excited to be here. My name is Joanne Lewis. I'm currently a 3L at the Howard University School of Law. And today, I'm just going to have a conversation with you to share what I have been doing with my LexisNexis Fellowship Project. I decided to focus my project on the topic of increasing entrepreneurship and ownership for Black professionals within the law. So like my colleagues did, I'll just start and tell you about how I got interested in this topic. I graduated from Babson College with a Bachelor's of Science in Business and Entrepreneurship. Yes, there's a school that you can get a degree in entrepreneurship. And so part of the Babson curriculum as a freshman, at 17 years old, they give you $3,000 to start a business with your cohort. And so this was very life-changing for me. People, when I tell them this story, they're just like, well, what business did you start? So we started revolutionary, world-changing, glow-in-the-dark stickers for your laptops. So we're not here to talk about the business that I started, but I did have the experience of talking to manufacturers in China and marketing. And at a very early age, I learned the importance of entrepreneurship and ownership. For a young Black woman coming from Boston, not really sure of herself, this curriculum really changed my life. And I learned at an early age that ownership is leadership. Ownership is power. And so I aspired to one day be my own boss, and I did become my own boss in 2016. I launched a small business that deals with writing consulting. And currently, as a law student, one of my long-term goals is to one day own my own law firm. However, the reality is that a lot of the people that I saw in the positions that I hoped to be in, they did not look like me. And this was something that I realized was threatening the community of Black legal professions, but it also threatened the rule of law. And so that's why I chose to focus on this for my topic. So I created this program called the Black Ownership in Law Program. You can think about it as an incubator or accelerator program for Black lawyers who want to start their own business. So the first thing that I did was look at the stats, and this is what I found. Only 4.9% of law firms are Black owned. Only 2% of law firm partners are Black. And lastly, Black lawyers make up just 10% of senior leadership in the legal field. So these stats told me one simple thing, that Black lawyers are not in position to lead and are not in position to impact the legal field. So I wanted to go a step further to corroborate this information and see what were some Black law firm owners who were affected by these statistics. How did they feel in this situation? So I called up, a couple of Black law firm owners that I knew or that people referred to me through my mentors, and just talked to them about their experience. How was it like? What did you wish you had? What were some of the subjects that were difficult for you to grasp as you launched your business? Who did you wish was on your team when you started? And this information was really the foundation of my program. I didn't want to just create a program that would have a bunch of elements that I thought was necessary. I really wanted to provide for the needs of people who this program would be for. And so these statistics and the research that I did really formed the foundation for this program. And the program is going to be in 3 phases. The first phase is going to focus on feasibility. The second phase is going to focus on building. And the last phase would be focused on execution. There you go. And so for the first phase, the feasibility section, we would have experts or leading people to come in and to talk about the target market analysis that people would do. Who's your clientele? What are the services that you want to offer? Where are the people that you want to service? What are the incorporation documents that you need to really understand the feasibility of your business? The second phase is the building phase, and this is where I was really excited to find that LexisNexis has a plethora of resources through practical guidance to really help solo practitioners with launching their business and maintaining their business. So practical guidance has so many tools on accounting, marketing, really building a team, and so this is where the LexisNexis resources would come to help build the business for these law firm owners, future law firm owners. And then the last phase is execution. So having experts to come into this group of cohorts to tell them about social media marketing, to tell them about how to market their business to gain new clients, to tell them how to manage a team and manage payroll and all of those expenses, which were some of the concerns that I found that the people that I talked to had issues with. And so this incubator program really serves to help to diversify the workforce, but more specifically help to empower people who want to be their own boss, who want to really create a future and a legacy for their family. And so I ask you to really support me in this endeavor just by sharing your resources, by sharing people who you know who could mentor the participants who want to become their own law firm owners. One of the premises that I have is that I want people to not have to go through the same mistakes or not have to dig it through the ground. A lot of the people that were around me, maybe their parents were law firm owners and they were aspiring to do the same thing because they had that close proximity to people who did it in the past. And so, my colleagues and I were really passionate about diversifying the leadership of the legal workforce. And we really want you to dream with us. So won't you imagine that the next time that you walk into a federal court, like Christina, you will see that there is diverse, predominantly Black federal courts? Or won't you imagine that in a world where you walk into any legal workspace, like Nicole, you see predominantly beautiful Black and brown faces? And won't you dream with me and imagine that the next time that you go to a law firm, that you will see predominantly Black partners and owners? What a beautiful world that would be, right? Well, help us to make that a reality with your support. Thank you.
Thank you. And Joanna, you can stay right there. I'll start with you if I may. Talk to me a little bit, well, let's actually start with the cohort, as you talk about a cohort being gathered, and then you bring them through phase 1, phase 2, and phase 3. How do you get that cohort? How would you think about who gets to join that cohort? What would the rules of it be, if you will?
Yeah, the rules are not too stringent. We really open our doors to any person who is diverse and who wants to start their own law firm. We really hope that the cohort will be diverse, so people who have been practicing for a very long time, but even people who, straight out of law school and don't necessarily want to work at a law firm or work at a firm. I know currently it's really not possible. It's really not looked upon, but I've met some people, some of the people that I spoke to, they did start their own practice right after school, and so navigating that challenge. So it would really be a diverse program of diverse applicants entering into the program.
In your research, what did you find was the biggest obstacle for people who are entrepreneurs and want to start their own businesses?
I would say the biggest obstacle was not having a team. So a lot of people, they probably only had the financial resources to do everything themselves. And so as a result, they didn't hire a secretary or hire a social media person. And as a result, they got burnt out very easily. So in the program, we would use the expertise from people who had started their business and try to find a way to balance hiring, because you don't want to get burnt out, but also managing your finances to build a sustainable team.
Is part of the goal, since you want to increase leadership at some of the big firms, to get entrepreneurs to become successful and then eventually get them into those firms? And how would your program help in that transition?
Yeah, I don't imagine that I'd set goals for the participants. It's really going to be kind of like a program that they participate in, and they set their own goals and outcomes for what they would like to do post the program. I imagine that people would do a variety of things, either starting their own law firm or going back to, a partner position at a law firm that they worked at. But we would have the resources and the training and the development so that they could be empowered to do whatever it is they wanted to do in leadership.
A lot of what you're describing, if it's successful, is a lot of in-person stuff, which I think can be like amazing. Congratulations, you're successful. And then also like, oh my God, in-person stuff, as we've all learned during a pandemic, can have its own obstacles.
Yes.
Have you thought about digitizing a lot of these things, learning experiences that don't have to be in person? Do you see that as an opportunity to help people get those skills?
Yeah, there will be a mixture of both digital and also in person, because I don't think you can replicate the cohort dynamic, virtually. So there definitely will be a lot of touch points that are in person, but some of the courses that kind of teach the nuts and bolts of, I'll talk to everybody else, that teaches the nuts and bolts of, accounting or financing or managing a team, those elements would be delivered virtually.
I've been an entrepreneur for almost 10 years. I did not make glow stickers. Maybe sometimes I think maybe I should have just gone with the glowy stickers, and that would be less stressful. But we know that the data around Black entrepreneurs and funding is maybe just as bad as the data around Black female partners in major law firms. So how do you think about tackling that funding element, which is so critical for entrepreneurs? I mean, that's really what, when you talk about burnout, I think a lot of that is correlated.
Yeah, thank you so much for that question. It's something that I grappled with as I was building out my project. And essentially, I think that in the creation of the project, I would try to get as much sponsorships as I could from different companies who really believe in the mission, to make some of the to make some of the program aspects free. I did have an idea of having practical guidance, have like a 3-month free trial if anybody wants to, sign off on that. But those are some of the things that I was hoping to provide to the aspiring law firm owners, because as you mentioned, it could be difficult. So a mixture of just sponsorships. I think this room is very powerful. I'd kind of work my network to see what people would provide if they believed and supported the mission.
Excellent, great presentation, thank you. What do you think is the biggest reason that explains that terrible gap? I think you said it's 1% of Black women.
Mm-hmm. So it was less than 1% of Black and Latino women that achieved equity or non-equity partnership status. And I think much of that is, I think the workplace is still looking at women and saying, wow, these are working moms that don't have time to litigate or don't have time to be attorneys. And I think that much of the workplace is still founded on seeing women and seeing them as moms and not as attorneys.
What is the message that you would like corporations and law firms to really understand? And do you think there's a way to change a mindset which has been stuck in a lot of ways?
Well, for women, I want them to understand that children only make us stronger. They only make us better. And they only make us work harder. So seeing a woman who is a mom at a firm means nothing. I mean, they are empowered, they are beautiful, and they birthed a child, so they are strong.
And extremely efficient with their time,
yes.
Let me tell you.
Sleep can be deprived.
Excellent presentation. Thank you so much. May I get a round of applause for our third cohort? Absolutely excellent. Thank you, guys. We move on to our cluster number 4, which is diversity and equity in the courts. May I invite cluster 4 to please come up to present.
Good morning, everyone. My name is Naja Basfield, and I had the pleasure of working with Cluster 4. You're probably looking at the screen and wondering, who is the lean team? Well, I'm gonna help you out. L is for LJ, E is for Idris, A is for Aquila, and N is for Naja. I'm a 4L evening student at the University of the District of Columbia, David A. Clark School of Law. And today I want to talk about something that concerns me. This issue is regarding biases. In my cluster, which is focused on diversity and equity in the courtrooms, we looked at it in 3 different ways. Biases by police officers, biases through prosecution, and also biases in the public. My title of my project is Ally Legal, it's your digital pathway to the courtroom under the 6th Amendment. When you think about bias and thinking about how it is implicit, I want you to take a step back and think about a gentleman driving in a vehicle. Imagine yourself being Mr. Johnson. You're driving on a Friday, enjoying your evening, and you're stopped by a police officer. And at that moment, if we think about Mr. Johnson at that time, he is frustrated, he is angry, he is upset and wondering, why did you stop me? He hands him a traffic citation. Because believe it or not, people of color are often given traffic citations and default judgments at an alarming rate more than our white counterparts. And what does Mr. Johnson do with the traffic citation? He tosses it on the ground of his car to never look at it again. Mr. Johnson will receive a hearing notice, which he doesn't attend, a failure to appear notice, which he does not acknowledge, and a default judgment. And for the non-lawyers in the room, a default judgment is when a court can take money or attach your property and pay your debt. And if we think about Mr. Johnson at that time, this traffic citation, I didn't do anything, where does it stem from? And it stems from implicit bias. Implicit bias is a prejudgment that's given towards a group of people based on their race, gender, or even socioeconomic status. And ladies and gentlemen, this problem of implicit bias is exclusive to people of color. Each and every day, brown and black people drive their vehicle, and think about Sandra Bland. She drove her vehicle, stopped by a police officer, and it resulted in her death, ultimately, but in negative adverse consequences to people of color. However, we must communicate to stakeholders, such as you all in the audience, and even you all online. Communicate with the judiciary, with our legislator, and the public. And when I spoke to my mentor, Ms. Serena Wellen, she's sitting in the audience with the black and white dress, and also the first-year fellow, Mr. Oscar Drawn, to figure out how can we combat implicit bias with driving and its connection to having a person of color suffer default judgment that takes away finances from their household. And she put together a lovely, lovely team of LexisNexis developers who created this application. And this application is called Ally Legal. And on the next screen, you'll see a demonstration from Sandar. I thought about doing the voiceover of this demo, but Sandar put in so much time, 3 hours on working on this for me, that I thought it was only right that he show you the demo. And I'll play on the next screen. Can you play the video, please? Thank you.
Hello, everyone. As a first step in preventing implicit bias, we built Ally. Ally Legal, when it's fully complete, will help you navigate through the Florida system. Currently, it helps in navigating the Leon County system. As you get started, we would like to know about whether you were arrested or have a mandatory court appearance. If neither applies to you, you can navigate through the application to the next step. As a subsequent step, we ask you about whether you have a citation ticket at hand. If you do have, please proceed along. We also show you an example where you can pick the citation or the section from the ticket that you've been handed over. Once you have it handy, go ahead and enter the citation into the box, and the box shall help you in picking the correct one. As you pick one, now click on the continue button, and we will show you a glimpse of what the legislation is about that you've been charged with. In this case, it's a careless driving. As a next step, we also give you warning about the number of days that you have once a citation has been handed over to you and the subsequent actions you can take. After which, after which you can navigate to the next step in order to pay the fine or take another corrective action. Payment is two ways. You can either pay the entire fine or you can enroll in a payment plan. Paying the entire fine takes you to the Leon County system where you can go ahead and start your transaction to pay the fine. Or if you wish to enroll in a payment plan, go ahead, click the next button. But at which point we also give you options in terms of what is going to entail in terms of going through a payment plan. If you're happy about it, you can still continue and go ahead and start your payment plan. In a gist, that is LA Legal as a first step in preventing implicit bias. Thank you.
And I'm very empowered that this can build a bridge between technology and the judicial system. If we think about how we can empower people of color, because we have a charge to help those in marginalized communities. They will have judicial access at their fingertips. If we can download Snapchat, Facebook, and TikTok to give us the best restaurants, where to stay in different states, then why not empower people of color to have them feel not inferior about the judicial system, but have some control and ownership and feel good about themselves? Because at the end of the day, this is not only an application for people of color, it's for all of us. Because the goal should be to provide digital access in this time. Thank you. You will now hear from one of my favorite persons since I met during this LexisNexis Fellowship, LJ, who will talk about bias through prosecution.
Good morning. My name is LJ Chavis, and I'm a third-year law student at the Southern University Law Center in Baton Rouge, Louisiana. And I'm here to talk about progressive prosecution tactics. At the age of 16, I was charged with a crime. However, it was a prosecutor who ensured I walked away without a conviction. This project is important to me because I feel like people need to know the impact, the power, and influence of the prosecutor. It is my hope that after this presentation, you will understand the power, the impact, and the influence of the prosecutor in your community. I first want to start off with, what is progressive prosecution? Progressive prosecution is a legal theory that focuses on rehabilitation, juxtaposed to the traditional sense of prosecution, which focuses on punishment. This is a very controversial legal theory in that a lot of legal scholars, professors, and lawyers find as though this is a step in the wrong direction. And they think that progressive prosecutors are soft on crime. However, this is not the case. I have stats to prove why this is not the case. Currently in America, we have 330 million people. That's just 5% of the world's population. However, in America, we have 2.3 million people in prison. That's 25% of the world prison population. And 70% of 85.9 million people in America who have a criminal record, 70% of them have been jailed. So why do we need progressive prosecution? Diversion programs. Diversion programs are an alternate way to prosecute. They give people an alternate way to still be held accountable of their actions, but yet not walk away with a criminal record. The impact in the community is positive in that people are able to re-enter the community and work and provide for their families. And it gives people a second chance at life and a positive role in having a positive impact with the legal system. My time at LexisNexis, I had the opportunity to speak with prosecutors and learn and understand the role of progressive prosecution and how it can help out in the legal community. As you can see, the stats are amazing, alarming. So what I want you to do, I want you to vote. I want you to know who your prosecutor is. Challenge them, ask them what they're running on. Because if it wasn't for a prosecutor taking a chance at me at 16, I wouldn't be here today. Thank you. And now I would like to introduce my fellow Jaguar, Idris Stagg.
Thank you, LJ. And as he mentioned, my name is Idris Stagg. I'm a fourth-year law student at Southern University Law Center. Thank you. Although the way that I'm dressed, I look like an assistant coach for Coach Prime at Jackson State. So I had to make sure that I put a little flair on it to let y'all know who I'm with. I certainly want to take this opportunity to thank my mentor, Jackie Hall. She could not be here, but if everybody would do a quick favor for me, turn to that camera in the back and say, "Hi, Jackie." Thank you. I know she's going to love that. Text me, Jackie. And in her stead, Steve Carroll, who will be speaking on her behalf. Soledad, you said that you wanted to go to law school. My chancellor is also here. He actually came down here specifically for that. I talked to him on yesterday. He said, "I'm going to recruit Soledad on tomorrow." All right, now that I've gotten all of the introductions out of the way, let's talk about really what we are here to talk about. I want everybody to take a moment and to think about, imagine if you or someone that you knew was on trial, accused of a crime, and on trial with the threat of their lives, their liberty, or their property being taken away from them. And imagine that that person looks to the judge, the person with all of the control in the room, and he says, "Your Honor, this jury box is not representative of who I am. This jury box, it has little or no black people, brown people, or whoever you identify with in this jury box." And the judge's response to the person who is on trial for their lives, their property, his response is, well, the reason why it's not reflective of you is because of the fact that your community do not answer the call. When the jury selection questionnaires are sent out, no one in your community sends them back. And so this research that I did while I was a LexisNexis fellow had me to really do the research as to why that is. The jury selection process is a long one, and my research focused specifically on the way that the jury lists are created. And so with the survey that we took, it was a 15% gap between black citizens and white citizens of Louisiana as it relates to their trust that the jury selection system process is fair. And so I hope that I earned your commitment on today in order that we can ensure that the Sixth Amendment is applied the way that it was intended, which is to make sure that everyone who is accused of a crime has access to an impartial jury. So what I'll be talking about on today are 3 points. One, how is the system biased? And what are some current tools that we can use in order to make sure that we change that? And then thirdly, what are the next action steps that we can take in order that we can get to a more just society? So first, how is the system biased? When you think about the eligibility of a juror, the only thing that you have to be in America is 18 years of age, must be able to read, write, and speak the English language, and also to be a citizen of the United States and of the jurisdiction in which you're supposed to be a juror. Yet, the process that we use in order to create those selection lists involves using such things as voter registration rolls and property rolls. And as we most know, that back in the 50s and 60s, it was quite difficult for people of color to get on voter registration rolls. And so some of those thoughts and those beliefs are still there as it relates to not wanting to be involved in the process. Secondly, the antiquated delivery of the jury selection form is another reason why people do not answer the call. If you notice on the back of your badges, I saw QR codes. When we were talking about the Gavel League, they put the QR code up, everybody put their phone up. These are the ways in which people who are not my age currently communicate with each other. And so we have to look at the antiquated delivery. Thirdly, the accused, when there is not a fair cross-section of the jury, the accused is responsible for proving the fact that there is not a fair cross-section of his community up there. As the story that I related earlier stated, he saw that there was a problem, but how can he prove it if there's no information? So what are the current tools that are available? Big data. My time here at Lexis has allowed me to see behind the scenes. LexisNexis uses algorithms in order to pull in data from courthouses, pull in data from public records, to pull in data from this place and that place, and to create all of these wonderful, great platforms that we use. Everyone who has a smartphone in their hand and are on TikTok or Facebook or wherever they are, whatever they're doing on social media, they have the access to gather that information behind the scenes, where they know your name, where they know your phone numbers, where they know your addresses, where they know what color purse you like. It really doesn't matter, but there are billions and billions of gigabytes of data that's currently being collected every day. And then, of course, I spoke about it a little earlier, but the QR codes, simple ways that we can pass information and have communication between two people without worrying about whether or not the address is correct. And then finally, streamlined processes. My mentor, Jackie, we found in Massachusetts that they use at a state level the jurisdiction and the processes in which they use, as opposed to how it is in Louisiana, where we have 64 different parishes, 64 different ways that the juries are created. In Massachusetts, they do it at the state level. So what are our next action steps? We need to utilize this automation and technology. We need to ask that our jurisdictions are more transparent with the information, how they collect the data, how they use the data. And then finally, we need to educate ourselves. Make sure that we understand what the processes are for. Make sure that we understand how important it is to be on voter registration lists. I hope that this has motivated you to answer the call in order that each of us can have access to a free and just society, in order that we can have access to justice. Thank you. And that
Hello, everyone. Can you hear me? Yes. Hello, everyone. I am Aquila Gardner, and I'm a 3-0. I think the mic is back on. Yeah. Oh, thank you. Technical difficulties are guaranteed. Hello, everyone. I am Aquila Gardner. I'm a 3-0 at Howard University School of Law. Thank you. And I did my research project on how we can use AI and technology to reduce jury bias. But before we get into that, I just wanted to talk about bias in general. We've all probably experienced bias, whether due to the color of our skin, our sexuality, our socioeconomic status, or just where we grew up. While there are all biases are not created equally. So my project focused on jury bias, more specifically on racial bias in regards to the jury selection. And with my project, we wanted to focus on this because it has a harmful impact. When you think about these biases impacting someone's guilt or innocence, regardless of just focusing on the merits of the case. And as you know, as Edris has already highlighted, the Sixth Amendment guarantees individuals accused of a crime a right to impartial jury, even though we don't always see that to be the case. And as Edris also pointed out, there is a underrepresentation of people of color. And when you think about the harmful effects of wrongful convictions as well as excessive sentencing, this is a critical issue. As such, I was really passionate about researching jury bias and decided to focus on North Carolina because I'm from Washington, North Carolina. So my project focused on, I see somebody's from North Carolina. So my project focused on multi-phases. So the first phase looked at determining is there bias. And we also polled North Carolina's community with that portion of our survey. The second part of the project focused on how do we find a solution and how do we expose this bias that I'll talk about a little bit later. So for the first part, is there bias? We did a general population survey in North Carolina where we had a total of 300 respondents. And this is what the survey looked like. And in this survey, we asked a variety of questions. We asked, have you ever been summoned for jury duty? We asked, if you had ever been summoned, did you serve on the jury? As well as questions to gauge their trust. So if you were ever accused of a crime, do you think you would get a fair sentence in North Carolina? And here you will see some of the results as well. So you can see it's much lower for those who self-identified as Black and Hispanic, as for those that had been summoned for jury duty. You also see it's much lower for those who said they actually served on the jury for those that are Black. Finally, at only 31% for seeing if you trusted the jury process, you see that it's much lower for those that identified as Black at 31%. So based off of these results and seeing, yes, there is bias, we decided to create an interactive tool. And this tool is a combination of all of our research throughout the year. So all of our research, finding, and data, and as well as an interactive dashboard that will allow anyone to expose the bias. Using 2020 census data, we try to get an idea of what would a jury look like if it was more representative of the community that it's supposed to serve. So I'll take you through a really quick demo. It is mobile friendly and it's live if anybody wants to go to it and see it for themselves. But just to talk a little bit about the dashboard, and this is me doing a screen recording. So this is about the project and about the Sixth Amendment and what it guarantees. From there, you can see the dashboard that I mentioned previously. And in this dashboard, you can see the different counties of North Carolina. And you can kind of just see me clicking around. I just wanted to show all of the work that Dan and Steve and the rest of the team put in to make it very interactive. And here you have like Halifax County and what you expect to see of the jury composition for Halifax County. You also see Wake County, but I'll just focus on Alamance County. That's on the screen to the right. So for Alamance County, they have a total population of 165,000 people. And from that, using the 2020 census data, we determined that if you were to see a jury composed of what it represents the community, according to the census data, you should expect to see between a minimum of 0 and a max of 1 person that is represented as Asian. You would expect to see between 2 to 3 jurors who are Black. You would expect to see between 1 to 2 jurors who are represented as other, as well as, I believe, 8 to 9 jurors who are represented as white. So we really wanted to create something to give the community and community activists concrete data, concrete and real data to show this is what we would expect to see and to push for change in legislation, as well as help us to reduce jury bias. So as my final call for action, I would like you all to join me to push for representation. And with pushing for representation, we've already begun this work by increasing visibility with the survey, as well as with the dashboard. And from that, we are encouraging other fellows to continue this work and to continue in different states. As Edris mentioned in his presentation, the same survey has already been used in Louisiana, and we saw similar results. So with that, we hope that you answer the call and that you push for representation. Thank you.
Thank you, Aquila.
Also, and a big thank you to my team. I just want to say this would not have been possible without Steve, my mentor, Dan, our UX designer, Deronda, our research analyst, and Michael, Bob, and Chris, our research analysts. Thank y'all so much.
Fantastic. Great presentation. I'm going to keep you up there and ask you some questions. So explain how you think diversity impacts bias on a jury. Like, let's say we're able to solve the problem and you make the jury more diverse. How do you think that impacts jury bias?
That's a great question. I don't think diversity on its own impacts jury selection, but just from the fact that you have the diversity of ideas and the diversity of experiences. I know we talked about this a lot at lunch yesterday. So I think it helps to bridge the gaps, and it helps you to catch things that somebody else might have missed just based off their own bias.
What do you think is the best way, because you're measuring jury bias and you're adding transparency so people can see it and understand it. What's the best way to get rid of it, do you think?
The best way to get rid of bias is, one, to educate yourself as much as possible and on other cultures and just learning about different people's experiences and acknowledging that bias and working through that as well.
In your mind, would removing jury bias be literally removing some jurors, just saying like—
And that too, yes.
Unsolvable, you need to go.
Yes, making it more representative of the community that it supports. So if the community is half black or, whatever's represented in the community, that should be reflected on the jury.
Bias is kudos to you guys trying to solve like a giant, very entrenched problem. How optimistic are you that something like AI could really make strides in dismantling something that is so entrenched and so challenging?
Yes, so I know AI has a very merit past, or I guess just it being recently, there can be bias in anything. So I know there's a lot of research on how using AI can kind of like implicate that bias, but I feel like some of that is also due to who is programming it. So having a diversity even in the people who are programming the AI technology, as well as I feel like this project would be centered on focusing on bias, so that would decrease the chances of that being like a side effect of it as well. But I feel like technology and AI, we're in a new world where technology is part of everyday life, so how can we use that to make positive change?
That's a great question. Thank you, appreciate it.
No problem, and thank you.
You bet.
And I'm sorry, on behalf of Cluster 4, we just want to say thank you to all the mentors as well. Really appreciate it. And LexisNexis for all the support.
Adrias, come on up. You talk a lot about shifting the process of jury selection, but I'm interested, before we talk about the process, to talk a little bit about the narrative. And as a person who has tried to dodge jury service for a long, long time myself,
Yes.
I mean, truly,
Yes.
like, I'm not gonna lie. I think if you were to poll people in the street, they would say, jury duty sucks. Like, I don't wanna be part of that. And it was until I heard your presentation that I really thought about it a different way. So I'm curious if you've thought about narrative shift. We'll get to what you report on, which is the processes that have to change.
Right.
But sometimes the narrative also is, who'd want to do that?
Right, and I absolutely agree with that. When I started the process of researching, the jury selection process in itself is a very long process. It starts from how our community perceives jury selection, going down to court and actually serving on the juries, having to spend the time, having to, go down there and in some cases not be paid by their jobs. And sometimes it brings on a hardship that most African Americans just flat out don't want to deal with. And so we do need to change that narrative, because it could be any one of us, regardless of our race, our ethnicity, whoever we are. It could be any one of us who are affected by allowing government to be unimpeded with their resources to take our life, liberty, or property.
What would be the first way that you would think about changing a jury list?
Particularly using big data, depending on the people to understand what it's about. A lot of times when people think about, the facts that they're using their cell phones and that this information is being generated or garnered, it's like, that's my information, right? But you're also voluntarily giving that information. And oftentimes you have to consider the risk with the benefit as it relates to how it is that you're going to use the information that's gathered.
And how about how you would change the delivery? I mean, do you worry that you leave people out when, I think changing the delivery can add more people, but it can also leave people out. And you're right, the number of times I've gotten jury notices mailed to places that I haven't lived in the last 5 years.
For sure.
Clearly the delivery is flawed. How would you shift that?
I think that it's not so much as that you stop sending it snail mail, because my mom, hi mom, definitely uses snail mail.
Tread carefully here.
She was at jury duty a couple of weeks ago, and I'm sure that she got it in the mail. So it's not so much as taking away the snail mail, because there are people who use it, but there are younger people who would go to TikTok for their information before, they go to, a newspaper article or TV.
No offense taken, don't worry, totally fine. What law school were you trying to recruit me to? You mentioned the data and making that data available, which I always am a big fan of the transparency. How would that look? How would you make that data available if in fact you could be transparent about the makeup of a jury?
Yeah, sure. I think that it's important to partner. Partnerships, collaborations, like I said, there are many companies who are doing it, household names that are using it, that are doing it, collecting this big data, and having the governments to partner with some of these companies, or encouraging them to partner at the very least to figure out how it is that they're collecting the information to where they can get what's necessary in order to create the list, strictly name, address, age information, in order to create the list, to send the forms to the proper persons to answer the call.
So you see it as an add-on to technology platforms that already exist, just
Absolutely.
becomes another element.
Absolutely.
Excellent. Thank you very much, appreciate it.
Thank you.
LJ, I'm gonna call you up. I have found the stories around progressive prosecutors really fascinating. And yet we know there's major pushback to some specific. I mean, Krasner is a great example, right, who was duly elected and yet is going to probably be impeached, would be my guess. They're pushing for that. So I'm curious if you've thought about some of this pushback and how that can be, how do you use the research that you're finding and the narrative of your own personal narrative to help push back on the pushback, if you will?
Well, I feel like the first thing you understand is that the government has unlimited power in the criminal justice system, and that in using that power, you need to have really good people in those roles, right? And you need people with learned experiences in those roles who has been the accused, and so they know what it's like to stand in front of a judge and jury and have their life at stake at liberty, right? So I think the first step is just knowing that the power you have and putting good people in those roles, and also having a team around you who supports you. And that starts at the legislative level, that starts at being a part of the bar associations, and being in places like this as well.
So just being out loud about your advocacy,
Right.
sounds like. I always ask questions about narrative shift because I'm a journalist, and I think this is a really tricky one because the narrative right now is around we're in a crime wave, and I remember watching the news when everybody was talking about that horrible killing in Wisconsin, and suddenly it was about bail reform, and you're like, Wisconsin doesn't have bail reform. Why are we talking about bail reform? You know, it just completely, so, but there's a narrative, right, that seems to be really challenging. How would you think about narrative change so that the story of progressive prosecution being successful is something that people lean into versus what I feel often happens, the reverse?
Well, the narrative needs to be created off of facts, and the facts are that progressive prosecution works. The facts show that people who are given chances don't re-enter the criminal justice system. And so the narrative needs to be based on facts and not assumptions. People are scared of changing the way things are. And that's a problem we have now in the legal world, that, you know, people are not wanting to change and adapt to how things are now. So I think if we base things off facts and we get involved in elections, we get involved with like teaching law students in the legal community and lay people. Well, lay people, that's like regular people, not regular people, but lay people, their influence of the law, and then I think we can change the narrative that way.
Some of us lay people are thinking about going to law school, just throwing it out. Final question for you, LJ, if I may. Are there particular jurisdictions that have been moving forward in progressive prosecution model that could be held up as examples that you would point to?
Yes, so there's a big movement in terms of like associations. There's the National Black Prosecutors Association, which is filled with progressive prosecutors from, I think, like Marilyn Mosby in PG County, Maryland. Not Marilyn Mosby, PG County. Her name was Alicia Braveboy in PG County, Maryland. Marilyn Mosby in Baltimore, Larry Krasner in Philadelphia, Marcel Clark in the Bronx, Ariane Waddell in Florida. So there's tons of jurisdictions that are implementing these tactics.
Excellent. LJ, thank you very much.
Thank you.
Nadja, can I bring you up? I love this digital model. I worry sometimes that a digital model leaves out people, especially people who we know are already at a disadvantage when it comes to technology and even infrastructure for technology. Is that something that you've thought about?
I have, and the good part of it is grandparents have grandchildren that understand technology and understand how applications work. And so the goal was, if your grandmother or your uncle who just have a high school education, reach out to the children. I believe someone spoke today about the children and getting to the prisoner pipeline. These children are very smart, and as far as like navigating this application, we thought about how can it be brief, user-friendly, and help a layperson understand the next steps.
And would there be, of course, there are folks for whom the internet is consistently unreliable. Would there be any, I don't know what the right word is, like real life version, you know, where it can exist in multiple platforms and forms, so if you can't access it through the app, there's other ways to find it?
The goal is to make it cloud-based, but to also have LexisNexis and myself push to having the Google Play Store and also the Apple Store.
Excellent. Thank you very much for your presentation.
Thank you.
For our cluster number 4, appreciate it. Thank you. Great job. And I'm going to invite cluster 5 up for their presentations. Cluster 5, I should mention, is equity in the criminal justice system. Welcome.
Thank you, thank you. Good morning, everyone. Oh, thank you, that's great. My name is Talia Thomas. I am a third-year law student at the Howard University School of Law here in Washington, D.C. Thank you. And as Soledad mentioned, I, along with my cluster mate, Amari Roberts, are going to talk to you about equity in the criminal justice system. More specifically, my project focuses on systemic racism in our capital punishment system. And to begin, I have a statistic for you. Hope this works. Ah, there we go. So, since 1976, in cases where the offender was white and the victim black, only 21 of those offenders have been executed. However, in cases where the offender was black and the victim white, 226 of those offenders have been executed. I'm going to let that sit and marinate with everyone for a little while because those are some very heavy statistics. Now, while you're thinking about that, and we're going to hear from me for the next couple of minutes, I'm going to allow my colleagues, Pam and Stacy, to tell you about the greater implications numbers like that have on our criminal justice system, especially our capital punishment system. Can you play the video for me?
Statistics like an overwhelming number of people who are on death row are there because they happen to be a person of color and the person who was killed happens to be white. It should give us great pause. Because the flip side of that statistic is that the number of black victims who are actually, whose killers are brought to justice with the same, whatever, vengeance or the same fervor is pathetically small, which just tells us that the prosecutors are again and again making a decision that defending a white life, trying to create a system of retribution and deterrence around the killing of whites is far more important than doing the same thing around black lives.
Those numbers are indicative of where the system is and the purpose behind it. And you know, people who support the death penalty talk about deterrence and retribution and all of those things, but when you look at it for the numbers that you presented, the stark difference is obviously those are not the reason. We actually had to read an article by the Death Penalty Information Center on the historical underpinning of capital punishment, how basically this is just lynching at another name and lynching by the hand of the state as opposed to like a lynch mob per se.
And that is a clip from a video that I produced in conjunction with the publication that we have for our LexisNexis Fellowship, and I titled it Stranger Fruit. And it's a slight nod to the song Strange Fruit by Billie Holiday, in which she speaks about lynchings that occur in the South, and she was almost suppressed from singing about this song because it told about the realities of Black people living in the South, which was not something we wanted to discuss at the time. And going back to the Stranger Fruit video clip, which will be available later for you all to watch via the LexisNexis Fellowship website, it is a nod to how, like my friend Stacy explains, that these numbers can be considered a lynching by the hands of the state. Because when we consider the people who are passing down these judgments or bringing these cases to court, who are elected by us, our prosecutors, they are there to protect the interests of the state. And we see that in the 38 states that still employ the death penalty, 98% of those prosecutors are white. And this is very significant because they serve in mostly 40% Black communities. And as you've heard from my fellow cohort mates, they largely employ juries that are not representative of the communities that they serve. They use tactics and strategies like using their preemptory strikes to ensure all white juries. And this is also significant because we know, and studies have shown, that people sitting on juries are more likely to judge more harshly along racial lines. But the buck doesn't just stop with prosecutors. We have to bring our defense attorneys into the conversation as well, because on appeal, the number one cited claim is ineffective assistance of counsel. And much of that can be attributed to lack of experience and lack of understanding of the procedural laws that govern capital punishment cases, also known as the Anti-Terrorism and Effective Death Penalty Act of 1996, or commonly known amongst the legal field as AEDPA. So what do we do to combat the systemic racism that we're seeing happen in the capital punishment system? Well, we can do one of three things, but I'm hoping we will do all of them. First, we should introduce law students to careers as federal defenders and to the capital punishment system and the laws that govern it at an earlier stage. Myself, as well as my colleagues Stacy and Pam, are all products of the Capital Habeas Pipeline program at Howard University School of Law. And as students of that program, in our first semester, we were introduced to all of the case law and legal theories behind capital punishment. And we were able to see how the case law developed and landed us where we are now, that drastic statistic. We were also given an opportunity in our second semester to be placed with capital habeas units and federal defenders, not only as mentors, but to do the work. We're working on cases, writing appellate briefs, and dealing with clients who are on death row. So the goal is to introduce students as early as possible so that when they are finally lawyers and attorneys, they've been working with these very complex statutes for a while. They've seen the ins and outs. They've seen all of the procedural bars, and they know how to handle them in an effort to mitigate the harm that they could place on their clients. We can also do more pro bono hours. The one thing that this fellowship has shown me is that there are lawyers willing to do the work. All of our mentors are lawyers or in the legal field, and they've dedicated numerous hours to us, to helping our dreams come true, to bringing our projects to fruition. And that's because they knew about the opportunity and were presented with the opportunity. So we should guide them to help clients who are on death row and use their talents to do exactly that, to help these people to be the barrier between clients and a system that we know does not necessarily work in their favor. Lastly, we can educate the masses, because while my goal right now is harm mitigation, the ultimate goal is abolishing the death penalty. So, in closing, I'm asking not only you, but law students, law professors, everyone in this room and everyone watching to do the work, get involved, and make sure to be the change that you wish to see in the world. And again, while my goal is harm mitigation, the end goal is always abolishing the death penalty. And you're going to hear about how my clustermate intends to do that in the state of Georgia. Thank you so much.
Good morning, everyone. My name is Amari Roberts, and I am a third-year law student at Florida A&M University College of Law. Thank you. My project is abolishing the death penalty in the state of Georgia due to its racial disparities on people of color. So just to give you a little background about why I chose this project for this fellowship program, I am a Georgia native. I was raised in McDonough, Georgia by my two lovely parents sitting in the background. Thank you. And this man that you see here, his name is Warren McCleskey, who was also a Georgia native. The landmark case of McCleskey versus Kemp was based on Warren McCleskey, who was convicted of a capital crime and brought his case all the way to the Supreme Court. In front of the Supreme Court, he argued that although he's been convicted of this capital crime, it's an injustice and he has the statistical data to prove it. Now, I just want to give you a little bit of context behind Georgia's death penalty system. Its origin is from slavery. You heard that correctly. Its origin is from slavery. That means, ladies and gentlemen, that if there was a slave who either escaped from slavery or attempted to escape, they would be convicted of a capital crime and they would be hanged. Throughout Georgia's legislature, the history shows that the only thing that changed throughout time was the execution method. While the racial disparities stayed the same, while the numbers grew, the only thing that changed was the execution method, going from being hanged to going to the electric chair, and now where it currently is today as lethal injection. So going back to Warren McCleskey, the Supreme Court told him, we hear you, we see the data, but it's not enough to show that Georgia's framers were intentionally racist in drafting the death penalty law, and so he was executed. What you see here is 22 versus 10%. Those numbers represent African American inmates that were executed who had a white victim versus white Americans who were executed on death row that had a black victim. Throughout my research, in my time being a fellow with LexisNexis, I was able to use the LexisNexis product StateNet. And what StateNet did was show all of the recently enacted legislation across the country, as well as any pending legislation during my search of the death penalty. And one of the states that recently enacted abolishing the death penalty on its basis of race is California, who passed the California's Racial Justice for All Act and became the 22nd state to abolish the death penalty. And so what I wanted to do with my project, the McCleskey Act, which is a model bill, I wanted to use an excerpt that included a racial justice reform that states that anyone who is convicted of a capital crime will not be executed on the basis of the color of their skin. And so what I want you all to do today, ladies and gentlemen, is in your respective hometowns, in your respective states, stay informed. Know what's going on with your state's legislature. Challenge the laws. If you see anything that doesn't quite make sense to you, if you hear anything that confuses you, get involved and see what you can do as a citizen. And with that, ladies and gentlemen, I close. Thank you so much.
So let's begin, Talia, actually, no, I'll start with you, Mary. Let's start with that. Clearly, the race of the victim in both of your conversations plays a role. And I'm wondering if you've thought about any way to mitigate that, because it seems to have a ton of weight in the disparity that ends up in prosecution and then ultimately in conviction and even, I'm sure, sentencing. Have you thought about strategies around that?
Yes, so one of the strategies that I thought about was directly going to the source of where these racial disparities are happening, which is within the legislation of our laws regarding the death penalty. And so if you look at your own state's law that talks about sentences where the death penalty is enacted, you won't see anything on its face that's reflective of any sort of racially disparate impact or anything reflective of intentions to be racist. But if you look at the overly broad criteria let's take a prospective juror. They can use that overly broad criteria and misconstrue it to mean whatever they want it to mean. And just to give you an example, in the state of Georgia, the official code of Georgia annotated 17-10-2 allows a juror and allows a judge to use the inmate that's on death row, their character, in choosing the sentence of their conviction. And so on its face, you just hear that you're using the inmate's character. But what that really means is that you can use their prior record, you can use any sentences that they've had, you can use what their beliefs are regarding certain crimes, and with that is how you create the implicit bias that we see in the criminal justice system. And so to answer your question, when I look at rationales for that, I think that the sole answer is to just take the legislation apart bit by bit and see what we can do to create change in it, and I think that'll help mitigate systemic racism.
You mentioned the California ending its death penalty, and I'm wondering, are the states similar enough to use California as a model, or are there some just gigantic differences where it's an example of a state ending the death penalty, but it's not got enough overlap with Georgia that it would be a good model?
Well, you know, every state is different. Every state has different numbers regarding the racial disparities in the death penalty system. But honestly, ladies and gentlemen, any person that's been wrongfully convicted of a capital crime that's on death row is one too many. And so while the numbers may be different, the implicit racial bias that's in the death penalty system is something that needs to be reformed.
Final question for you. Obviously, you're from Georgia, mom and dad from Georgia, but obviously this is not just about Georgia, and it's not just for people who are within the state lines of the state of Georgia. What's your message for those people outside of the state?
Outside of the state, I just want you all to be more involved. If you aren't already aware of your senators or your House of Representatives or any laws that they're looking to pass within this upcoming year, I want you to use products like StateNet and see what's going on. It's been very helpful in my study, in my research, and my time as a fellow, and I think that it'll help you all as well. And most importantly, get out and vote.
Thank you for your presentation. Excellent. Appreciate it. Talia, will you go up to the mic, please? So you say law students don't necessarily get enough exposure to understanding capital punishment, and I'm curious if you think that early exposure or earlier exposure plus work would get more students interested, and how that ultimately down the line could affect the system in a positive way.
Sure. I always think it's good to have more time with any one piece of material. You really get to pick it apart, get comfortable with it. My presentation, I've been doing this, I've been speaking about this topic for 9 months. And, depending upon who you'd ask, I could be considered a subject matter expert. And
definitely,
thank
yes.
you. So I think that earlier introduction will just give someone an opportunity to be more comfortable with the knowledge that they're receiving. EDPA is a very complicated statute. It took me all of last year, and I'm still learning, to understand it, to understand the statute of limitations, to understand all of the different procedural bars, to understand how to write effective briefs to show that this client wasn't treated fairly. There was evidence that was admitted unfairly. And bringing up a student in that way shows them that, even if they decide post-grad not to pursue this career field or this track, there are always pro bono hours. Due to our professional responsibilities, we should have at least 50 a year, 50 pro bono hours a year. And I think To us, 50 hours may not seem like a lot, but to a client or two clients, that could be the, bar between life and death for them. And I think it's very important to give students that opportunity to see how they can make a difference, because, we all know, social justice reform, implicit bias, the things that we deal with most often, police brutality, but there are people who are tucked away because we've decided they've done something so bad that they don't decide to live anymore. And that's an area where we can make some change too.
You mentioned that EDPA is complicated, so I'm just going to take that opening to jump in and say, explain it to me, please, in layman's terms, if you will.
Sure. So in 1996, EDPA was introduced as a way to, or I believe, increase judicial efficiency. What the court wanted to do was limit the times that a client or a defendant can come up into court and raise all of these different claims about things that happen within their trial, whether rightfully so or not. And it instituted a statute of limitations, which has tolling periods and things of that nature. It also defined what type of claims and that you could bring to the court, whether it be evidentiary or otherwise. So EDPA really serves to create procedures to somewhat funnel these capital punishment cases through the court to make it more efficient and to allow clients to have an avenue post-conviction to be reheard on things or matters that they feel weren't considered during their trial or during their guilt phase.
Great, thank you. Clearly, the race of the victim has a role in whether or not someone is executed for their crime. The race of the prosecutor matters. The race of the jurors as a whole and the jury as a whole matters. Do you see a way or any way in which we could make race matter less?
I'm not sure if we can make race matter less, but I do think that we can get ahead of the problem. In one of the articles I was reading, it was actually a book called Enduring Justice in my capital punishment class. It spoke of, how there are all of these bars, of course, procedural bars, and one of them being bringing claims about jury discrimination to the court. And it's a very high standard to show the court that I indeed suffered from jury discrimination, therefore you should either set aside my conviction or allow the case to be reheard. And one of the solutions that it proposed was having a presumption of discrimination. So that means when you bring your claim to the court, they are already presuming that you were discriminated against. And it would be incumbent upon the non-moving party to defeat that presumption. And I think that's very significant, because if we continue in the standard that we have right now, the bar is so high that clients at this level, they don't have a right to counsel. So you have to factor in costs to getting attorneys. You have to factor in their overall, intellectual knowledge about the system, knowing whether or not they need an attorney. Many of these clients, because they cannot afford attorneys, are writing these briefs themselves or petitioning the court themselves. And me as a law student going through it, it's confusing and difficult for me. So to expect a client, someone who is not well-versed in law, someone who has not been trained to, petition the court for anything, you're already adding another barrier to the conversation by not having a presumption of discrimination. So I feel, since we can't remove race from the conversation, we should set the bar somewhere that makes it more fair to discuss.
It's almost like inserting it in the conversation.
Yes, exactly. Address it,
realistically.
exactly.
Excellent, excellent presentation, ladies. Thank you very much, appreciate it. So, Adonica, we're about 7 minutes early. I'm gonna give everybody And this is a group that when you say 7 minutes, I know you're going to be back here in 7 minutes. A chance to take a bio break, a chance to just stand up, stretch your legs, refill your coffee before we get to our 6th and last presentation group. Thanks. Buddy, those of you who are by the coffee machine, and because these doors are a little transparent, I can see who you are. Come on in. Wouldn't that be funny if you like literally just start naming people? Bob, come back in. We're about to restart. Oh, the chimes are going. That's such a much more relaxing way to be invited back in than being yelled at while you get your coffee. Okay, we have our 6th presentation. Welcome.
Good morning for just a little longer. My name is Zuri Ward. I'm a 3L evening student at NCCU School of Law. Thank you. And my cluster members, Brianna Joasis and Lauren Skorupski, sorry, Lauren, and I have focused our project and our cluster on knowledge and wealth and ownership and racial equity. Again, my name is Zuri Ward. I'm a 3L evening student at NCCU School of Law. And my project, Umbrella, focuses on addressing systemic racism through providing access and education about intellectual property to Black artists and creators. So a lot of the passion behind my project started last November when I had an opportunity to attend the Black Entertainment Sports Lawyers Association's annual conference. And there, I heard an attorney talk about how he demanded certain contract provisions for his clients to make sure that some of the historical issues with systemic racism that he knew they were faced would be automatically addressed through the provisions of that contract. And through that, I started to feel a responsibility to impart justice, not just through criminal justice or through public interest, but in the areas that were of interest to me, which is entertainment law and intellectual property. So in the United States, intellectual property is really about ownership. And ownership of intellectual property gives you the ability to sell your work, to reproduce your work, to license your work, or to do nothing with it at all. However, when Black artists don't have that ownership, that's a lost value to them. So their family members can't do anything with it in the future. They can't choose to do anything with it while they're living. And so that's something that's really creating an issue. So as I was doing my research about, for the purposes of this project, I focused on copyright law specifically and as it pertained to music and copyright law. So as I was doing my research, I found that there wasn't a lot of scholarship on it. There wasn't a lot of information out there about it. But there's one person, Kevin Green, Professor Kevin Green, who's a professor at Southwestern School of Law, who talks about it all the time, extensively. And so I kept finding myself coming back to his work. And through reading all of that, I saw that there were 4 major areas where systemic racism was having a big impact on Black artists, in copyright law. One of the problems is Black music isn't always understood, or Black art isn't always understood by mainstream America. And because of that, the cultural expression that comes through like jazz interpolations or hip hop sampling hasn't always been protectable because it's not always considered music, or it hasn't always been considered music. There's also gatekeeping, so there's been a huge lack of access to information about what constitutes a copyright, when you have a copyright, what you need to do to assert those rights, or what you need to do to protect yourself against infringement. Also, we're all here because we agree that systemic racism exists. And where that exists, there's always a problem with financial barriers. So even if you have all the information in the world, there may be an issue with having the money to file a registration, or if you do have a registration, when it's time to protect yourself against infringement and hire an attorney, you may not have the money to do that. And then there's just outright theft. So there have been times historically where, in the past, in copyright law, initially it was about it was about who was the first to file, not necessarily who created the work. So even if you created something intentionally or by the seat of your pants, if someone came behind you and ran to the registration office and said, hey, this is mine, it was theirs. And that, again, that's a lost value for you and your family in the future. So my solution is Umbrella. And I don't know if I can. Can you play the video, please? It's here. Thank you. An Umbrella is a web-based solution, a website that is geared towards providing information to Black artists and creators and entrepreneurs about how to protect their intellectual property rights. Again, I focus on copyright for the purposes of this project, but I'd like to see it expand. And it was really important to me that the website reflected, was appealing and reflected the people that would be able to use it. We were able to use some practical guidance and, I don't know where Natasha is, and use some Lexis associates to record some informational videos, and we wanted to have a lot of resources for law school clinics, for other resources where people could go to get assistance. And then there's also some examples of creators who could benefit from Umbrella. And so this is an example of the law school clinics being zoomed in, and ideally you would be able to see these all around the map where people could go to get assistance at low to no cost. So I challenge you to open your Umbrella. And how do you do that? You do that through supporting programs like Umbrella to make sure that there's access to information for these artists. Secondly, you can find ways to support. So you can support your local nonprofit organization, your arts organizations, or you can find a single artist that you know or maybe that you don't know to find out how you can directly impact whatever they have going on for a project or a season or just in giving them whatever that they need. I think that's the best way to create impact in the United States and globally because it really is intellectual property that sets us apart on the world stage. So in medicine, in technology, in art, intellectual property is what makes us shine. Thank you so much.
Hello and good afternoon, everyone. My name is Brianna Joasis, and I'm a third-year law student at the Southern University Law Center. Thank you. My project aims to combat an issue that hits home for many minority home seekers in both the past and present, but hopefully with the implementation of my evidentiary tool, not the future. So let's talk home valuation and the biases within the appraisal process. I'd like to start with a short story. An African-American couple purchased and financed a home with the intentions of making renovations and selling it for a higher profit. This we call flipping homes. Over the span of 3 years, they made multiple renovations, bringing the home estimated value from $575,000 to $1.45 billion. And in doing so, they realized with much success, they wanted to try again. So they sought a third mortgage to go ahead and see what they can procure to go ahead and do another home and flip it. And in doing so, this required a new appraisal. And with this new appraisal report, what the family did is they brought in an appraiser, but what they did is they left the home filled with family photos and African-themed art. When they received the inspection report, it was significantly lower than the initial $1.45 billion. So what they realized is there was something potentially occurring here, but they weren't sure how to face it. And in doing so, they requested a second appraiser to come out and reassess the home. But this time, they removed all family photos and African-themed art. And can you guess what took place? The next inspection report came back at the initial 1.45 million. This, ladies and gentlemen, was a blatant example of racial disparity. And it's a real story. It's the case of Tate v. Austin. I'm sorry.
Take this, please, and the clicker is, as you guys can see, has a mind of its own. So I'm going to give you this. Will the mic help you?
No, I'm good.
Okay.
Okay. And eliminating bias and discrimination in the home valuation process is essential. And we know this because legislators have actually created laws and statutes to combat this specific issue. We have the Fair Housing Act of 1968 that prohibits discrimination concerning the sale and rental and financing of housing based off of race, religion, sex, national origin, and family status. There's also the Uniform Standards of Professional Appraisers, which is tasked with creating standards which appraisers must follow to remain an impartial third party when assessing these real estate properties. But even with these enactments that are charged with safeguarding and protecting fair and equal values, we still have occurrences of this till today. So this is how I've realized that there is a gap in the current structure that is still failing the minority people. And that's when I bring you the action plan. The action plan is an evidentiary tool in the shape of a checklist, as you see here. It is going to be published in real estate association websites, also LexisNexis platforms. The checklist will be in the form of a hyperlink using a fillable PDF format. It's going to be broken up in sections, as you see here, that will allow appraisers to create detailed reports of the assessments and the observations when assessing the properties in real time. As far as the consumers, they'll be able to refer back to this and arm themselves with an evidentiary tool to combat potential discrimination practices that they realize amongst the evaluation of homes. And in this, I charge you with my last few words, which is check and protect. Thank you.
Good afternoon. Hello. Y'all hear me? Good afternoon, everyone. My name is Lauren Skorupski. I'm a third-year law student at Southern University Law Center in Baton Rouge, Louisiana. Thank you. My project is geared towards building generational wealth by protecting Black property ownership through sharing the importance of estate planning and creating wills for the Black community. Individuals aspire to leave a legacy when they pass away, whether that legacy is to the entire world or if that is to simply just their heirs and their family. The American dream is to buy, build, and own property. This has been the American dream since our founding fathers of our country. However, this American dream is not the same for the Black community due to the disproportionate impacts that property and succession laws have on our community. When an individual passes away without a will or estate plan in place, the property is subject to the intestate laws of that state where the property is situated. For those of you who may not be familiar with intestate laws vary from state to state, and intestate laws allow the individuals to break down the property according to their heirs. So the state has put in statutory provisions of how the property will be distributed amongst their heirs. And this is a big issue. A lot of people are not familiar with who actually are their heirs, who are family members that are able to inherit in their property. So then property ownership gets split up fractionally amongst their family members, and property ownership gets lost. This comes with an issue that comes about with real estate spectators who do title searches in the courthouse to find out who actually is owning a piece of property. This is a big issue in the southern region of the country. Real estate spectators will find the most remote property owner let's say, a property down in Louisiana, and they'll find a property owner up in New York that has an interest down there. They will contact that property owner, buy out their interest at a very low rate, because simply that heir in New York does not realize that they have that property down there in their name. So the heir in New York is like, okay, I'll take the $5,000 that you're offering me for these 20 acres of land. I have no idea what you're talking about. So that's a big issue in the Black community. Congress has stepped in 2018 to pass the Uniform Partition of Heirs Property Act. This act has allowed the community to protect the generational wealth amongst families. However, with this act passed by Congress, not every state has adopted this act. To be clear, according to my research, only 22 states have actually adopted the Uniform Heirs Partition Act, which is a big issue. With the Uniform Heirs Partition Act, it allows a proper due process procedures. It gives the individuals proper notice, which in a regular partition auction that goes through from the real estate spectators, without this protection, those heirs are not familiar or unaware of the partition that is their property being put up for the partition. But with the Uniform Heirs Property Act, that gives them due process of notice. It allows them to receive a fair appraisal values, like Brianna has mentioned, and allows the court to essentially play referee through the auction sales, and allows the court to make sure that the individuals are each obtaining the proper proceeds according to their shares. The big thing that is very important here is education. Education is fundamental. We must raise community awareness of this issue and how easy it is that property rights from Black Americans can be stripped immediately. In order to combat this issue, succession planning is critical. Succession planning is very important to protect the assets as well as to build that familial generational wealth. I do want to point out a statistic. 29% of Black Americans have indicated that they have a will or estate plan in place. That is leaving 71% of Black Americans without a will or estate plan in place. 71% of Black African Americans who can be susceptible to these forced partition sales and lose their property right from under their hands. And a quote that I put up here, everything you worked for, everything you've earned and created has the ability to benefit future generations. It is extremely important that we advocate for succession planning within the Black community, as it can protect the heirs' property and property of all of our ancestors. As part of the LexisNexis Rule of Law Foundation's initiative to end systemic racism, I have created the heirs toolkit. Heirs can be broken down into helping individuals with real property descriptions and educating in succession planning, hence heirs toolkit. This toolkit includes a 50-state LexisNexis survey. For those of you not familiar with some of the LexisNexis products, on practical guidance, there are 50-state surveys that the team has created that breaks down the statutory provisions within each state in the 50 states across the nation, as well as the US territories. So with help of my mentor, Dave, as well as Joseph Collins from LexisNexis, I was able to compile all of the state laws regarding the intestate laws, whether the state has adopted the Uniform Partition of Heirs Property Act, as well as the general partition rules, the rules for notice, and who can actually commence a partition agreement. In addition to that, like I mentioned, education is critical. I have created a brochure that will allow the layperson to actually understand what heirs property is, as it is a legal term that no one's really familiar with out there in the world. So this brochure here breaks down what is heirs property, who can be an heir, the importance of succession planning, as well as the importance of knowing who your heirs are by creating family trees. And this brochure can be passed out to local bar associations, student law clinics that focus on real estate and wills and estates planning, as well as legal aid societies that do pro bono work. I just want to leave this with you. It's extremely important to protect property rights. Everyone in this room and everyone online can do their job by simply telling their friends and family the importance of planning for your future families by creating an estate plan and put wills in place. That way you can protect your property rights. Thank you.
Excellent presentations, thank you. I'm curious if you think, I mean, you mentioned both, if you think the focus needs to be on wills and shrinking that giant number of people who die and sort of the courts have to divide up their property,
Right.
or if there's a strategy that you would more weigh toward would be fixing legislation around it. If you had to
Right.
pick one or the other, what would you say?
I think the easier, simpler task would be simply educating the community on establishing those wills and estate plans in place. You know, our legislators, we can really push for our legislative body to, enact this Heirs Property Act. But through my research, I did find that around 15 states have proposed this bill in 2020. However, they didn't pass it. So that's a big issue that, legislators, they don't think it's that big of an issue. And we know that it's not that big of an issue to them because it may not directly be affecting them.
Are there laws in place that protect heirs from having their partitions forced upon them? Are there remedies legally?
Yeah, so other than the Uniform Heirs Partition Act, there is no legal remedies out there that can protect their heirs. When you go through this process of the forced partitions, a lot of state laws do not require the notice requirement. So a lot of individuals are finding out that their property is being taken from them by a simple knock on the door by the sheriff showing up at their house saying, your property is being seized and now it's going to be sold.
We did a documentary on this issue and the Gullah Geechee communities, and what you saw often was that you're unable to, you see a lot of estimated $50 million properties because they're waterfront on Hilton Head, right? Where everyone's living in a trailer because they actually can't leverage the value of that property to get a mortgage to, in any way. What do you think is a strategy to educate people outside of, or even get that brochure into the hands of people? I have found the minute you start talking to people about wills, and maybe especially black people, and maybe especially my parents,
They
just
get frightened.
like everyone's like, oh my God, we're talking about me dying, and they shut down completely. And I think these are the same people whose hearts break as they realize what they had hoped to leave their children gets divided up. So I can't figure out how to close that gulf.
Yeah, I think it's extremely important to just emphasize that when you die, you're not taking that property with you. You have family with you.
Not sure that would work on my mom and dad.
But you have family members that, they can pass it down to you, pass it down to their children, and keep building that generational wealth within the family and keeping that property there in the family. That way the family can continue to grow. And as part of getting someone to actually want to draft a will, there are a lot of misconceptions in the Black community that, hey, I don't own enough, or it's too expensive. But that's where all of us attorneys and legal aids and the bar associations can all step in and do the pro bono hours, like Talia mentioned. We have pro bono hours that we can put in that we can take the time and actually set up clinics to help with wills and estate planning for the Black community.
I think that's a great idea. Thank you very much. Great
Thank you.
presentation. Donna, will you come on up? So you talked about bias in the appraisal process, and I know that story well. It was both a shocking story and not a shocking story, right? I mean, so I'm curious if you think the problem is there's bias in appraisers. Is the problem there are not enough appraisers of color that might, in the